Oh, I forgot. Give me 1 second. I forgot. Am I live? I'm live. What up? What up? What up? What is up? I'm sorry, yo. I looked at the time and it was 6:25. So I got up and I swear I did like one or two things and I turned around and it's like past 6:30. I was like, oh crap. How are you guys doing? Welcome. I'm here. A little bit slow, a little bit hungover. I almost wasn't gonna do this stream because I was like, damn, this thing is like, let me see, it's like almost 4 hours long, 3.5 hours, bro. Like, do I got 3 hours in me? I didn't want to get out of bed. Let me show you here. Let's see. Yeah, this thing is like 3 hours, bro. Mira todo eso ahí. That's a long time. But yeah, how you guys doing? I'm sure a lot of people probably saw this thing already. The Gabby Petito hearing. Petito family versus the Laundrie family. Zanime texted me earlier too and said a couple of things. The only thing I will say, that Kylie Rodney's grandfather had a stroke back in April due to stress that YouTube brought on, and the doctor said it was stress induced. And then the other stuff I'm not going to mention, but pretty interesting. Okay. So yeah, we're gonna watch this video, man. I don't know. We're gonna chill and hang out. Watch this. It's almost 4 hours long. Carly says, "Did y'all see the PA grand jury subpoena Kohlberger?" Oh yeah, Kohlberger's parents. Did you message me that? Somebody sent me that too. I mean, I haven't looked it up myself. Somebody sent it to me somewhere. Oh, I gotta call Kona's mom. I forgot about that. My bad. All right, let me get my headphones before we start. I left it. Sorry about that. I could not find them anywhere. I didn't mean to make you guys wait. That's why they should stay at the computer, right? Shouldn't move around. All right, let's start this. Let's see. Fast forward. Boom, boom. Let me make sure plugged in. Okay. What's that? What'd you hear? What did it sound like? Ah! I was trying to find my headphones. Just keep skipping forward.
Here on defendant Laundrie's motion to dismiss the second amended complaint, which is DEN 91, and defendant Bertolino's motion to dismiss the second amended complaint, DEN number 98. Am I at all off on any of that?
No, Your Honor, that's everything.
Are there any others that we thought we were going to hear that are not, that I didn't list?
If there are, I'll be surprised.
Okay, great.
No, Your Honor.
Fantastic. Okay. I'm going to ask you all's opinion on which we believe is best to be handled in what order.
I think the motions to dismiss should be heard first, Your Honor.
I would agree, Judge.
Okay, wonderful. And which motion to dismiss do we wish to hear first?
Judge, Mr. Luca and I flipped a coin, so I will go first on behalf of Mr. Bertolino, if that's acceptable to everyone.
That is acceptable.
Bertolino.
To me, if you'd like to continue, sir.
Thank you.
Spicy attorney. Sip on some tea. Today I had some soup a little earlier.
Police Court.
Yes, sir.
Judge, once again, Chuck Meltz and Laura Kelly, on behalf of Mr. Bertolino, we're here today on the motion to dismiss the second amended complaint as it relates to Mr. Bertolino. Mr. Bertolino, as the court's aware, was added as a defendant in the second amended complaint. The counts against him appear at counts 3 and 6. Although the counts are not labeled, it's clear from the history of this case and the nature of the allegations that the counts are premised on intentional infliction of emotional distress. And because of that, they derive from the Restatement of Tort, section 46, which sets forth the various requirements for that count. Various Florida cases have interpreted that, all of which we'll discuss. Understanding we are here on a motion to dismiss, the way I plan to argue this is really to focus on the second amended complaint, as the court must do. Understand that the court must accept the allegations of the second amended complaint as pled. However, when we go through the second amended complaint, I believe what we're going to be able to show is that those allegations fail as a matter of law and do not establish a cause of action for intentional infliction of emotional distress. We will also focus on the purported language that's at issue, Mr. Bertolino's comments as cited within the second amended complaint, which our position again is do not support a claim for intentional infliction of emotional distress. We'll talk about the different cases that have interpreted this particular cause of action, look at the illustrations that are in the restatement, all of which are informative as to what does and does not reach the level of intentional infliction of emotional distress. And our position at the end is going to be that the entire cause of action against Mr. Bertolino is due to be dismissed. And if for some reason the court doesn't get that far, there are certainly parts of the cause of action which clearly cannot be sustained, irrespective of any other argument set forth. I would also add, Your Honor, that we're mindful of the history of this case. And in making the argument today, we will absolutely cite to the cases that Judge Carroll cited to in his last ruling. The Liberty Mutual case in particular is very informative, and also talk about some of the commentary from Judge Carroll that, again, previously dates our time in the case. So, Your Honor, just to start off, before we dive into the second amended complaint, it's been around for a long time, but intentional infliction of emotional distress is a infrequently pled cause of action. It's a cause of action.
So let's pause for a second, because I saw in the chat, somebody said about why burn after, Gigi said why burn after reading. So there was like this letter, I guess, that Roberta Laundrie had wrote to Brian Laundrie, something about like offering to help, like offering a shovel or something. And it's believed, I don't think the letter's public, like it hasn't been released publicly. Let's take a look at this video. But like people believe that like she knew about the murder before that, yeah, that Gabby was dead. Chris and Roberta Laundrie have not been charged with a crime in connection with the Petito's death, but in the civil suit, they asked to deny the Petito family's request for a copy of the letter, which purportedly mentions Roberta offering to lend her son a shovel and to bake a cake with something inside to spring him from prison, according to the Petito parents.
Do you love getting high, but...
Do you like getting high? Yeah. Take something that doesn't get you high. Oh, that what to put the combination. THC and CBD.
Petito's parents accusing Brian Laundrie's mother of offering to bury a body in a secret letter the mom wrote to her son. The Laundries are being sued by Gabby's parents for emotional distress over the pair's 2021 road trip that ended in her murder. While they confirm the letter exists, they say it predates Brian and Gabby's trip. Our next guest has been following this case since the beginning. Fox Nation host Nancy Grace joins us now.
Oh, no, Nancy.
Okay, so one of the lawyers said, hey, yeah, I went through some papers with the FBI and I saw that the mother wrote him a letter.
Yeah, you know, this letter, if it exists, and I have reason to believe it does exist, having been in the custody of the FBI after Brian Laundrie committed suicide, remember, out of that Carlton Reserve, 25,000 acres of basically swamp. This was found in his backpack, we believe, and it says, and I quote, would bring a shovel to help bury a body, and on the outside of the envelope says, burn after reading.
And why did this boy burn that shit? That boy getting his parents caught up too. The Laundries, the dirty
Reportedly
Laundries.
written by Roberta Laundrie to her son Brian Laundrie after the death of Gabby Petito. This has come out as a part of a infliction of emotional distress lawsuit by Gabby's family against the Laundries and their lawyer.
Right. Well, here's the thing. And for their lawyer to say, oh, that was written before they made the trip, it's like, well, who are they thinking about burying then?
Is there another dead body we don't know about?
Shit. Right.
Of course, the response by the Laundries is, well, we don't have a duty to the Petito family. But if you look at what the Petitos are arguing, they are saying that the Laundries knew way back when that Gabby was dead.
Right.
And they went through with the charade of looking for her and letting the Petito family suffer as they frantically search for their daughter.
Let's talk another bit about another case you're covering every night on every afternoon on Fox Nation. Here is the bombshell moment when cops confronted Alex Murdaugh about whether or not he murdered his family. Watch this.
Did you kill Maggie?
No. Did I kill my wife?
Yes, sir.
No, David.
Do you know who did?
No, I do not know who did. Do you think I killed Maggie?
Oh, shit.
I have to go where the evidence and the facts
I
take me.
understand that.
It's very interesting. Alex Murdaugh says to the cop, do you think I killed Maggie? What's that about?
Well, and also look at his body language. If somebody accused me of killing my husband, David, and my only son, I would do a backflip. And
Yeah, homeboy just chilling. He's like, do you think I killed him? What? Me? No, not me. Do you think that? No, I didn't do that. Well, it's just like chill and relax, like fucking on 10. That's a lot though. 10 Xannies, that's too much, right? What happened? I was watching that. What happened? Also, by the way, with Murdoch, I shouldn't pause too much though, because this shit 3.5 hours, bro. We got all night here. Alec Murdoch, indicted on 22 federal counts of alleged financial schemes. I mean, I don't know. Grand jury indicted disbarred South Carolina attorney and double murderer Alec Murdoch on 22 charges in connection with schemes aimed at stealing money from his clients. Ooh.
Do you think Murdaugh's defense team has introduced enough other stories where somebody, it just takes one, somebody would have reasonable doubt?
It's a pretty good defense team. Hartpoulian is a great lawyer, but he's got to work with what he's got. So up to right now, no. But the defense hasn't even started their case.
Yeah.
So let's see what they do.
All right. Of course, you can watch Nancy's live coverage of the Murdaugh trial every day.
Murdaugh. All right. So that's the whole burn after reading. He was supposed to, I guess, discard this thing. He didn't.
That does not have a great track record in terms of what constitutes it or not. But what is abundantly clear from both the restatement and the cases that interpret it is that the threshold for bringing it is extraordinarily high. And so as the restatement itself says, it's not been enough that the defendant has acted with an intent which is tortious or even criminal, or that he has acted to inflict emotional distress, or even that his conduct has been characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Liability has been found only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civil.
So Mo was telling me it takes 2 hours before the Petito's counsel gets to talk. So I should maybe play it a little bit faster. Let's try 1.25 and see. It'll be a while. Maybe we could do 1.5.
Civilized community. Generally, the case is one which the recitation of the facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim, outrageous. So that is the threshold for pleading intentional infliction of emotional distress. So with that said, Judge, I would like to focus on the second amended complaint. And if you have our binder, it's tab C, which is where it appears. If you're looking at it electronically, I'm sure you have a way to pull it up. But let me know when you're there, and I'll move along.
I have it in front of me because I printed it, but I'm trying to find tab C here because it looks like
We have a small binder and a big binder. The big binder is the case law and some other materials. The small binder is the motions with the amended complaints.
I found it.
Excellent. So, Your Honor, the second amended complaint is a relatively short pleading that contains 6 counts. There are 2 distinct plaintiffs, Mr. Petito and Ms. Schmidt, and there are 3 distinct defendants, Mr. and Ms. Laundrie and Mr. Bertolino. Mr. Bertolino is introduced in paragraph 7 and 8, where he's identified as a lawyer who's licensed to practice in the state of New York. And then in paragraph 8, that at all times relevant to within the cause of action, Mr. Bertolino was acting as an agent for Christopher Laundrie and Roberta Laundrie. So the first alleged fact within the 4 corners of the complaint is that my client, Mr. Bertolino, the purported actor in the intentional infliction of emotional distress, is in a unique capacity compared to most who have come under this cause of action. He was an attorney providing legal advice and guidance and representing his clients. There's some additional information provided, Judge, but when we get to paragraph 20, this is where the background or the factual background starts to really come in. In paragraph 20, there's an allegation that on or about August 28, 2021, Brian Laundrie advised his parents, Christopher Laundrie and Roberta Laundrie, that he had murdered Gabrielle Petito. Again, it's an allegation in the complaint. Clearly, the plaintiffs can't have any firsthand knowledge of that, but they pled it. The court's bound by it for purposes of a motion to dismiss. It then goes on to say in paragraph 24, from August 27, 2021 until September 19, 2021, when Gabrielle Petito's remains were found at the Spread Creek dispersed camping area in Wyoming, plaintiffs were extremely distraught and were attempting to locate Gabrielle Petito.
Oh, wow.
And, Your Honor, this is where it's important to give our first real focus to what's in the second amended complaint. Traditionally, causes of action for intentional infliction of emotional distress require the actor to trigger the emotional distress. The actor says harsh words. The actor threatens physical violence. The actor embarrasses or humiliates a target with intent and malice. In this case, Your Honor, by the own pleading, the plaintiffs allege that as of August 27, 2021, they were rightfully so and understandably extremely distraught. And that becomes important, Judge Brewer, because that level of distress predates any conduct of Mr. Bertolino in this case. So as a starting point, again, four corners of the complaint, the extreme emotional distress, which is the ultimate byproduct of where we head to, predates Mr. Bertolino's involvement. Paragraph 25 then talks about the Laundrie family purportedly going on a family vacation. Paragraph 27, this is a reference to Mr. Bertolino, which really are few and far between in the second amended complaint. It discusses that on September 13, 2021, Brian Laundrie left his home. Mr. Bertolino gave a press conference or interview a month or so later and described that he was grieving. I'm not sure that has a particular relevance to the case, but it's just one of the few paragraphs where Mr. Bertolino's statement or conduct's actually referenced. Where we get to paragraph 28, this is where the first purported fact setting forth a cause of action for intentional infliction of emotional distress against Mr. Bertolino is alleged. And it says on September 14, 2021, with full knowledge that Gabby Petito had been murdered by Brian Laundrie, and it is believed that they knew the whereabouts of her body, Stephen Bertolino, on behalf of Christopher Laundrie and Roberta Laundrie, issued the following statement. And so again, paragraph 28, this is where the first purported fact setting forth a cause of action for intentional infliction of emotional distress against Mr. Bertolino is alleged. And it says on September 14, 2021, with full knowledge that Gabby Petito had been murdered by Brian Laundrie, and it is believed that they knew the whereabouts of her body, Stephen Bertolino, on behalf of Christopher Laundrie and Roberta Laundrie, issued the following statement. And so again, if we back up to paragraph 24, the emotional distress started on August 27th. Now in paragraph 28, we're at September 14, and this is the first purported act or conduct of Mr. Bertolino. Procedurally, Judge, paragraph 28 only contains a portion of Mr. Bertolino's statement that day. Based on discussions with Mr. Riley, there's no objection to the entire statement coming in. It's actually Exhibit A to our motion to dismiss.
I saw the stipulation as to that. Okay.
Thank you, Your Honor. So I'll read the entire statement, understanding that there's only a portion of it in the second amended complaint, but given the stipulation, it's all covered within the four corners at this time.
Understood.
So on September 14, 2021, Mr. Bertolino's office issues a statement, R.E. Ms. Petito. It says, statement for counsel from the Laundrie family. This is understandably an extremely difficult time for both the Petito family and the Laundrie family. So let's look at that first sentence. There's no objective way. There's no context or circumstance. There's no interpretation that can be given to that which would ever rise to the level of intentional infliction of emotional distress. The next paragraph. It is our understanding that a search has been organized for Ms. Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family. And again, Your Honor, there is no interpretation or anything else that you could apply to that statement which in any way makes it actionable under this particular cause of action. And then finally, it concludes, on the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. Before proceeding further, Judge, again, sticking to what's been pled here. In every instance of intentional infliction of emotional distress, the actor has targeted the recipient. In every case that's cited, in every illustration, in the restatement, there's always been a target, for lack of a better term, when it comes to words. There are other examples of intentional infliction of emotional distress. Showing autopsy photos was one of the cases that Judge Carroll cited too. But other than that very rare exception, there's all direct communications. And the reason there's direct communications, Judge, is because the actor has to intend the emotional distress to occur. There's intent, there's malice, and then there's recklessness. But in either of those or all of those scenarios, it's linear. The actor is doing something ultimately targeted towards the recipient of the conduct. Here, again, just sticking to the second amended complaint, what's been alleged is that the Laundrie's attorney, Mr. Bertolino, acting in that capacity, put out a press statement to the general public at large. And no doubt an argument can be made that Ms. Schmidt and Mr. Petito had access to it or reviewed it or read it or heard it. But in terms of the intent, in terms of meeting that high standard of the restatement, which is so high that even criminal conduct doesn't satisfy it, we have a lawyer for a client who's issuing a public statement that in and of itself is inactionable and totally appropriate. Again, what's within the four corners of the complaint. Paragraph 29, which now interprets that statement, alleges that for the Laundries and Stephen Bertolino to express their hope that Ms. Petito was located and reunited with their family at a time where they knew she had been murdered by Brian Laundrie was beyond outrageous. And again, that's an allegation. It's pled, and the court has to accept it, whether or not it's true. With that said, though, Judge, to express hope, there is not an example in the restatement, there's not a case, there's not a commentary, there's not a law review article, there's not a single situation which has preceded us here today before you in which someone expressing a hope, let alone an attorney, let alone in a general sense and not even a direct communication, there's not a single case which suggests that expressing a hope, no matter what the circumstances, could be considered intentional infliction of emotional distress. Furthermore, Judge, as we know from paragraph 24, the emotional distress already occurred. And what's not in the complaint is that the statement of September 14, 2021 actually caused emotional distress. So when we think about the elements of the cause of action, we first have to have the statement or the conduct, then it has to legally cause severe emotional distress. Second Amendment complaint alleges that the plaintiffs, Ms. Schmidt and Mr. Patino, were already severely distressed. It describes the statement on September 14, 2021, and then it does not allege that it caused severe emotional distress. It discusses purported ill will by Mr. Bertolino in making the statement. Without facts, it attempts to paint it with malice. Without motive, it attempts to paint it as improper, but it doesn't actually link it to causing anything. Paragraph 30 and paragraph 30.
Happy birthday, Hoax. It's Hoax's birthday. Amazing. So I guess right here they're trying to defend Bertolino, saying, this is his attorney, saying that he didn't cause emotional distress.
31 talk about the dissemination of it. They're really jurisdictional in nature. I presume there was a concern that there might be a personal jurisdiction defense, which we did not raise, but that's really the thrust of those counts or those paragraphs. Same for paragraph 34, talks about activity within the state of Florida. Paragraph 35 is interesting, Judge, because paragraph 35 talks about a letter on behalf of Ms. Petito's family on September 16, 2021, not to my client, but according to the Second Amendment complaint to the Laundries, in which they are asking for information about their daughter. Paragraph 36, it talks about, despite the fact that Joseph Petito and Nicole Schmidt implored Christopher Laundrie and Roberta Laundrie to tell them if their daughter was alive, and if she was not, where her remains were located, Christopher Laundrie and Roberta Laundrie refused to respond to either Joseph Petito or Nicole Schmidt. Your Honor, again, Judge Carroll talked about that concept, the concept of inaction or not responding last time, although while it was in the body of his order, it didn't actually make it to the ruling, which we'll talk about in a second. But paragraph 36 is not actually directed to Mr. Bertolino, so there would be no obligation for Mr. Bertolino to respond to the letter, understanding there was no obligation of anyone to respond to the letter in the first place. Paragraph 37, while Joseph Petito and Nicole Schmidt were desperately searching for information concerning their daughter, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino were keeping the whereabouts of Brian Laundrie secret, and it is believed they were making arrangements for him to leave the country. Again,
Yeah, well, I'll speed it up. We could try 1.5. I was kind of keep grinding up. Said this long-winded malarkey. Let lawyers charged by the hour.
and no facts to support that. It's an allegation. True or untrue, the court has to accept it. Paragraph 38, Ms. Petito's remains were discovered on September 19. Also at that time, Judge, Mr. Bertolino issued another statement. The news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family. That's the second Bertolino statement described in the Second Amendment complaint. And before proceeding further with that, as the court knows from our motion to dismiss, Mr. Bertolino is being sued for offering hopes and prayers. And hope is definitely something you can't get sued for. And prayers.
Okay, he's taking little jabs. You said Mr. Bertolino is being sued for sending what? Hopes and prayers? Oh, shit.
It certainly isn't. And again, as of September 19, 2021, a statement by Mr. Bertolino after the fact that the Laundrie family was praying for Gabby and her family definitionally cannot be actionable as a cause of action for intentional infliction of emotional distress. So now we're up to paragraph 39, and the court's basically heard virtually the entire factual predicate, whatever facts existed, whatever facts were put into the universe to support these claims, we've covered them. And paragraph 39 then tries to tie in causation for the first time. So remember, we don't really have a causal tie to the September 14th statement. There is no causal tie to the September 19th statement. But what paragraph 39 does is it essentially makes what I would call a refusal to disclose argument that's really separate and independent from the two statements I just read. Paragraph 39 says, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino knew of the mental suffering and anguish of Joseph Petito and Nicole Schmidt in not knowing the well-being or location of their daughter, and further knew that such mental suffering and anguish increased each day that Gabrielle Petito was missing. Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino further knew, and this is the key part, that they could prevent such additional mental suffering and anguish of Joseph Petito and Nicole Schmidt by disclosing what they knew about the well-being and location of the remains of Gabrielle Petito, yet they repeatedly refused to do so. So we have the actual conduct by Mr. Bertolino. Again, both statements, not targeted, not specific to the family, general in nature, made on behalf of parents who themselves were in an extraordinarily difficult situation. Some of the case law talks about the mental stresses that are on the parties. Clearly, the Laundries had those mental stresses as well. But where the prior paragraphs talk about actions, paragraph 39 essentially says, Mr. Bertolino and the Laundries, Mr. Luke, I'm sure we'll discuss this, what we're suing you for is for not stopping the emotional distress, not causing it, but not stopping it. We started experiencing it much earlier in time, and you didn't stop it earlier by telling us the status of our daughter and where her body was. And again, Judge, for purposes of a motion to dismiss, whether or not any of this is factually correct, the court must accept it as true. So that's what we're dealing with. There is no cause of action for intentional infliction of emotional distress for not stopping it. There's a cause of action for causing it under incredibly severe and extreme circumstances, but there's no cause of action for not stopping it. And paragraph 39 is attempting to do just that. It's making allegations that because of inaction, not because of action, but because of inaction, the emotional distress that had been ongoing since August 27, 2021 wasn't stopped earlier. And Judge, with all due respect, that's just not a cause of action that's recognized under Florida law. It's not a cause of action that has passed grace by the Supreme Court or any of the appellate courts. It's not a cause of action that's described in Restatement Second. It's not a cause of action that's identified in any treatise or law review article that we came across. But that's the cause of action in this case. And the only time, by the way, Judge, where it alleges that anyone acted with malice or great indifference is right after that. Right after they refused to disclose, it says, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino acted with malice or great indifference to the rights of Joseph Petito and Nicole Schmidt. Not with the September 14th statement, not with the September 19th statement, but with this concept of not disclosing something that they purportedly knew. 1 through 39, Judge, that is all the alleged facts that this court has to work with. Paragraph 40 then basically sets forth what the alleged wrongful conduct is. To briefly jump ahead, when you go to count 3, which is against Mr. Bertolino, and you go to count 6, which is against Mr. Bertolino, they consist of 2 paragraphs. Basically, we incorporate paragraphs 1 through 40, and then Mr. Bertolino, as a direct and proximate result of the willfulness and maliciousness of Mr. Bertolino, and then they say it caused damages. So again, the actual counts themselves, which don't have a title, which don't say they're for intentional infliction of emotional distress, which don't themselves identify what the purported wrongful conduct is within the counts, they're silent on that. So you have to go to paragraph 40 and piece paragraph 40 into counts 3 and 6. Paragraph 40 is a commingled count, which is obvious when we get to the A, B, C, D, E, and F part, because it essentially describes conduct for Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino as if all of them were acting in an identical manner. But nonetheless, what are the causes of action in this case, or what are the components that are alleged for intentional infliction of emotional distress? 40A, failing to advise the plaintiffs that Gabrielle Petito was deceased. So again, a failure to take action, a failure to disclose count. Again, as discussed by Judge Carroll in his order, there is no case law to support that. There's no argument that can be made to support that. Judge Carroll's comment was that if those were the only counts, the entire matter would have been dismissed. But yet in the order just said denied. And this is one of the difficulties with the way this case is pled. It really should be 1 count for each purported act of intentional infliction of emotional distress, because then that way the court could determine as a gatekeeper, does this count stay or not? And then if for some reason it stayed for summary judgment purposes, we could say, well, count 1, which is the failure to advise, here's our motion on that. Because the actual counts don't describe the wrongful conduct, and because paragraph 40 just lists it as an A through F, it does make it difficult to manage in terms of issuing orders and approaching the pleadings. But in any event, we're treating it as if A, B, C, D, E, and F are all individual or separate and distinct allegations of intentional infliction of emotional distress, because that's how they're described. But in any event, paragraph 40A, failure to advise. Paragraph 40B, failing to disclose to the plaintiffs the location of Gabrielle Petito's body. Again, another allegation of inaction, not an allegation of conduct that was intentional or directed, but simply inaction, discussed by Judge Carroll last time. Paragraph 40C, taking a family vacation, clearly that can have nothing to do with Mr. Bertolino, but again, because of the way paragraph 40 is pled, it applies to him, even though obviously it can't. Paragraph 40D, blocking access to cell phones, again, that one can apply to Mr. Bertolino. 40E and F, this is the September 14 statement of hope in 40E. Paragraph 40F, this is the September 19 prayers after Ms. Petito's remains were discovered. And Judge, that is the entirety of the facts and the theories and the allegations and the links. So linking allegations to conduct, linking conduct to causation, linking causation to damages, which is what's supposed to happen in the Second Amendment complaint. Those links are just not here. And so without going beyond the four corners of the complaint, on both sides, because obviously Mr. Riley can't stand up and fill in the blanks. They're either in the Second Amendment complaint or they're not. Based on what's in the Second Amendment complaint, and more importantly, based on what's not in the Second Amendment complaint, the Second Amendment complaint against Mr. Bertolino can't stand. Turning to law, Judge. The case law is clear that the court serves a gatekeeper function when it comes to intentional infliction of emotional distress. In the Liberty Mutual case, and Your Honor, this is in our case law binder, tab 66, but this is a case that Judge Carroll cited quite a bit in his order. It's Liberty Mutual versus Stedman. The site is 968 Southern 2nd, 592. It's a Second District Court of Appeals case from 2007. This talks about whether or not
this is from earlier. I mean, I am live right now, but this is from earlier today. So we're just kind of listening and hanging out. I almost wasn't even going to come on today. I was just going to kind of chill, but I said, you know what, just pop on for a bit.
Of action for intentional infliction of emotional distress. And this case, as every other that interprets it, identifies that threshold as a question of law for the court. So oftentimes we find ourselves at motions to dismiss where the court asks me, Mr. Meltz, isn't that more of a summary judgment argument? Isn't it factual? Whether or not a complaint sets forth a cause of action for intentional infliction of emotional distress is a question of law. So it's clear from the case law that Your Honor, at this somewhat early phase in litigation, has the legal authority and the legal requirement to make that determination. It's not for a jury to make at a later day. And it's also something that no deposition or discovery is going to affect because, again, we have to look at the four corners of the complaint and determine, does it meet this standard? And as the court in the Liberty Mutual versus Stedman case discussed, behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That's the standard. So we have to take that standard and we have to look at what's alleged in the Second Amendment complaint and see if it meets that standard. In applying that standard, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. Rather, the court must evaluate the conduct as objectively as is possible to determine whether it is, quote, atrocious and utterly intolerable in a civilized community, whether conduct is outrageous enough to support a claim of intentional infliction of emotional distress is a question of law, not a question of fact. So, Your Honor, you have the task and the burden of reviewing the language in the paragraphs that we just read through and determine whether Mr. Bertolino, offering hope on September 14th and offering prayers on September 19th on behalf of his clients, as their attorney, as their agent, in a general sense, non-targeted, with no reason, motive, or any other factor to make these mean-spirited in any way, but you have to determine whether those allegations rise to that level of utterly intolerable in a civilized community. And again, Judge, hopes and prayers can't rise to that level. And the allegations that there was a duty somehow not to be silent, but to disclose, that there was a duty to make the plaintiffs aware of whether or not Ms. Petito was alive, and if she wasn't, where her body was. That's just not a duty that exists under the law, and it's not a cause of action that exists under the law. And again, Judge Carroll incorporated that in his last ruling, and there's no case law to suggest anything to the contrary. We've cited other cases, Judge. They all say the same thing. It's a tremendous burden to show truly horrific conduct. That burden has not remotely been met here, yet alone tied into legally causing actual severe emotional distress or damages. Separate and apart from that, Judge, and I'm winding down, despite the fact that it's not properly alleged and can never be, and despite the fact that the law creates a burden that the plaintiffs can't hurdle. We also point out, as set forth in the restatement in various other cases, that separate and apart from those issues, even if the court were to find that this conduct was utterly atrocious, an attorney who was functioning as Mr. Bertolino did, who is representing the Laundries, who themselves are unwittingly and unasked for part of a horrific situation in which all of the events are ongoing as they were, it is legally permissible for Mr. Bertolino, as the Laundries attorney, to make statements like the ones that he did. And the restatement of torts is clear that when an actor acts in a legally permissible way, there cannot be intentional infliction of emotional distress. They give examples of a landlord who knows a family's sick, but they didn't pay their rent, so they're evicted. The landlord clearly knows that putting them out on the street would cause intentional infliction of emotional distress, but they were legally entitled to do so. In the various insurance company cases where the insurance company would ask about whether someone qualified for Medicare or whether they met certain conditions, even though there may have been a denial or delay in treatment, they couldn't be held responsible because they were legally permitted to do so. To suggest that Mr. Bertolino, as a Laundries attorney, wasn't legally permitted to make a statement to the general public of a hope and a prayer in an extraordinarily difficult circumstance would suggest that any lawyer acting in that type of circumstance would be at risk for unintentionally causing emotional distress, or unintentionally offending someone, or unintentionally causing someone ill feelings or grief. There's no way to navigate that situation. You have two families who are going through something no one can prepare for, something that no one should prepare for or ever expect. But both families have their own issues, and the Laundries needed Mr. Bertolino. Mr. Bertolino acted as their attorney, and as the Second Amendment complaint says, at all times he was acting as their agent, and as such he was legally permitted to make the statements that he made, which themselves are not actionable. Finally, Judge, I do note that Judge Carroll addressed the statements at issue, not really the September 19th statement, but the September 14th statement, where he talked about context. I would note, though, that Judge Carroll did not talk about context with Mr. Bertolino as a party, as a defendant. And also, Judge Carroll...
I am curious to see what the Petito family, what their or lawyers are going to say, what the argument's going to be. I don't know how much of a case they have against Bertolino specifically.
Carroll's discussion about context didn't factor in all of the other elements, such as causation, such as intent, such as recklessness. He simply addressed what was pled and filled in the context. With that said, though, Judge, the full statement creates a much bigger context, which Judge Carroll did not have the benefit of last time, which I think contextually makes the statement much more understandable and benign. And then secondly, while Judge Carroll discussed the Stedman Liberty Mutual case, he didn't talk about that part where it said, in applying the standards, the subjective response of the person who is the target of the actor's conduct does not control the question. Nor did he address that the plaintiffs weren't the target, because again, the statement itself was publicly disseminated. It's an emotional case. The issues are complex. There's no bright line rule. It's very doubtful we'll ever see this exact fact pattern again. But none of that changes that the Second Amendment complaint still has to set forth a recognizable cause of action, and it doesn't. And it's just white or black, Judge. And so with that said, the court needs to dismiss it. At a minimum, if the court doesn't dismiss it, then clearly those parts that need to be dismissed need to be dismissed. Those parts being the failure to disclose, the failure to act, the failure to speak, none of which is supported by law. So our position would be the entire Second Amendment complaint, or rather the counts against Mr. Bertolino, but I'm sure Mr. Luca will have a similar argument. But the Second Amendment complaint against Mr. Bertolino needs to be dismissed in its entirety. If not, it certainly needs to be pared down. And as to prejudice, Judge, I would note that we are on the Second Amendment complaint. There's been 2 prior amendments. This is the 3rd opportunity to set forth a cause of action. The framework to the count was clearly argued last time. Judge Carroll's order was instructive. The case law has been at issue. Presumably, if there were better allegations that could be met against Mr. Bertolino, they would be in the Second Amendment complaint, and they're not. So based upon that, our position is the Second Amendment complaint against Mr. Bertolino should be dismissed, and given the procedural history in the case, should be dismissed with prejudice. Thank you.
All right, thank you so much, sir.
Yo, whoa.
I'm gonna let Mr.
Yo, did you hear that? I swear I heard somebody say, "Thank God." Oh, let's go back. Hold up.
Be dismissed with prejudice. Thank you.
All right, thank you so much, sir.
Who said that? You guys heard that? About to put the volume up?
And given the procedural history in the case, should be dismissed with prejudice. Thank you.
All right, thank you so much, sir. Mr. Riley,
Ooh.
do you want to let Mr. Luca go when you respond to both of them, or did you want to go now and then?
Since their arguments are basically the same, I'm fine with Mr. Luca going now.
Okay.
Okay, okay.
May it please the court?
Absolutely.
Your Honor, I will try not to replow the same ground as Mr. Meltz, but I'm sure I will. So I just want to apologize in advance. So, Your Honor, in the plaintiff's response to our motion, they assert that we are simply trying to overrule Judge Carroll's order. Now, while we are asking the court to dismiss the action, which Judge Carroll did not do, our arguments in this motion are, for the most part, issues Judge Carroll did not consider. Most specifically, as Mr. Meltz pointed out, his client wasn't a defendant at that time. But there are other issues for my clients as well. At the first motion to dismiss hearing, the plaintiff's theory, at least as we interpreted it, was that the Laundries caused them emotional distress by failing to communicate about Brian and Gabby, specifically to disclose Gabby's whereabouts. And that theme is repeated again in the second amended complaint and also in their response to our motion to dismiss. So our primary focus at that first hearing was that the Laundries had a number of constitutional and other legal rights that protected their communications and activities, and thus they had no duty or obligation to act in a certain way or to communicate information. Now, Judge Carroll did agree that the bulk of the plaintiff's allegations did not support the cause of action because the defendants had no duty to speak under the circumstances. Now, I don't know if the court wants me to re-argue those points or if you would prefer that I just pick up from where Judge Carroll's findings.
I've read Judge Carroll's findings in the past, and I briefed them again this morning. So if you want to skip over that, you can, but it's your case to argue. So.
Absolutely. Thank you, Your Honor. And if you do have any questions about what we argued at that point, how Judge Carroll came to that, I'm happy to answer.
I'd be happy to ask.
So at the first hearing on the motion to dismiss, Mr. Bertolino's statement at that time was really just one of many allegations, and admittedly, we didn't focus on it in our argument, probably as much as we should have. However, Judge Carroll found that of all the allegations, because Mr. Bertolino's statement was an affirmative act, which, although in isolation did not rise to the level of outrageous conduct, that it's possible the plaintiffs could develop some context for it that could render it outrageous. Like I said, we didn't concentrate as much attention on the statement as the first hearing as we should have. And knowing now that it was the critical allegation in the case, we should have focused our arguments on that topic. So that's what I'll do now. In that regard, we're not asking the court to overrule Judge Carroll because Judge Carroll did not have the benefits of a lot of the arguments we're going to assert today. First, Judge Carroll did not have the benefit of Mr. Bertolino's entire statement. Plaintiffs only included the one paragraph out of the three paragraphs in the original complaint and also in the second amendment complaint. And as Mr. Meltz said, by stipulation, the court can consider all of those paragraphs for purposes of this hearing. Second, Mr. Bertolino's statements were legally protected both by the privilege afforded to the exercise of permissible conduct when it comes to a cause of action for intentional infliction of emotional distress, and also the litigation privilege. Third, whether the statement alone, as opposed to the other allegations that Judge Carroll found did not support the cause of action, was either produced or substantially contributed to producing the severe emotional distress. Fourth, whether Mr. Bertolino's public statement, again, as opposed to the other allegations, satisfies the requirement that it be directed at the plaintiffs and in their presence. And lastly, the addition of the allegations against Mr. Bertolino renders the allegations against the Laundries implausible. So first, Your Honor, Mr. Bertolino's statement is not outrageous. And Mr. Meltz read the statement. I won't read it, but I will talk about it. Whether the conduct is outrageous is a matter of law for the court to decide. And the plaintiff's subjective reaction to the conduct does not control. The statement itself must be objectively outrageous. Generally, an outrageous act is one in which the recitation of the facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim, outrageous. If I recited Mr. Bertolino's statement to the average member of the community, their reaction would not be to exclaim, outrageous. They would probably think it sounds like a statement they have heard many times before by an attorney in a public comment about a case. Basically, a statement that says nothing of substance and is an attorney just trying to say something favorable for one of his clients. In paragraph 39, which is on page 19 of the plaintiff's response to our motion, they acknowledge that the statements, and when I say statements, I mean the September 14th statement and the September 19th statement, without context, seem to be an appropriate expression of sympathy and understanding for the trauma which the Petito family was undergoing. Had they been said by anyone else but the Laundries or Bertolino, they would be interpreted as genuine and sincere. So basically what the plaintiffs are saying is the statements are not outrageous, but the plaintiffs did not interpret them as genuine and sincere, and thus it caused them distress. So going back to the standard, Your Honor, objectively, the statement is not outrageous, but subjectively, the plaintiffs interpreted it as such. That's not the standard for liability. The subjective interpretation of the plaintiffs does not control. It is an objective standard, and by objective measure, the plaintiffs even acknowledge that the statements are not outrageous.
Is it objective just taking the statement as it is without any context, or is it the objective person sitting in the same exact contextual position as the plaintiffs?
That's an interesting question, Your Honor, because the way that the case law frames it is an outrageous act is one in which the recitation of the facts to an average member of the community. So I would submit that the standard takes into account what an average person would think within the community, not necessarily the plaintiff in that position considering whatever the conduct is that's alleged to be outrageous. Now, I don't have a specific case that discusses exactly.
So far, and I want to hear the other side, Carly said, I'm not sure they have a case against a lawyer, but who knows? Yeah, I don't think so either. So far, I don't know.
How the court would consider
My
that.
question, because that's what I said. You said that. But has any court said that?
Your Honor, other than the quote that the outrageous act is one in which the recitation of a facts to an average member of the community, that is a citation.
Okay. You probably already said it, but just in case I.
Hang on, let me pull that up, Your Honor. And I'm guessing just off the top of my head that it's probably the Metropolitan case, but I will double check that.
Get some water.
So it's Eastern Airlines Incorporated versus King, and the site for that is 557 Southern 2nd, 574, page specifically 576, and that's a Florida Supreme Court case from 1990.
Okay. Thank you.
And Your Honor, I would also, in addition, again, citing the Metropolitan Life Insurance Company versus McCarson, the site for that is 467 Southern 2nd, 277, and that's again a Florida Supreme Court case. It's from 1985.
467.
467 Southern 2nd, 277,
Okay. Perfect.
specifically page 278. And again, that's the case that essentially adopted the cause of action for intentional infliction of emotional distress in Florida. And in that case, Your Honor, again, one of the standards that the court has to consider is the court must evaluate the conduct as objectively as possible to determine whether it is atrocious and utterly intolerable in a civilized community. Again, Your Honor, sort of referencing that the standard involves what a person within the community would think of it, not necessarily how a specific person in the specific position of the specific plaintiff might consider that particular conduct. But Your Honor, if you'd like, I can do some research after the hearing and submit a supplemental to the motion to try to
okay.
pinpoint that issue.
I can probably do it myself. That's the question that. It appears to me that Judge Carroll has already answered that question from a motion to dismiss standpoint, though. That's where I'm having some trouble with your argument. And I understand that you're saying, well, now we have the full statement. But you're saying that the full statement changes the context in which the middle part should be read.
Yes, Your Honor, that is my position.
All right.
Because I'll get to that, but essentially my position is that taking that middle paragraph in isolation, without the two paragraphs that both precede and follow it, because those two, the first and the third paragraph really do provide the context for why the plaintiffs wouldn't necessarily regard that statement as what they claim it to be. In other words, the explanation that Mr. Bertolino offers sort of puts it in the position of, hey, we know this statement might not be enough, but based on the advice of our attorney, it's all we can say. That's what the last paragraph of the statement says, which is important for our purposes because really what the plaintiffs are saying is you should have said more. And that's really what Judge Carroll said too, is there could be context where perhaps they should have said more in the statement, where the statement should have been worded differently, whatever it might be. Considering the context of that last paragraph, it's informing the plaintiffs, I'm sorry that this statement may not be to your liking, but based on the advice of our attorney,
distortion.
This is all that can be said.
Time distortion.
So that's our position. And Judge Carroll didn't consider that position at all because the full statement was not in the record at that time. We didn't argue those other paragraphs at all. And Your Honor, we believe that this is a fundamental flaw in the plaintiff's cause of action, is that it is based on their subjective interpretations and general cynicism for anything the Laundries did. For example, they claim that the Laundries' visit to Fort DeSoto Park was outrageous. And they claim that Mr. Bertolino's September 19th statement, in which he offers condolence and prayers for Ms. Petito's death, that's outrageous. That's a subjective assessment. I mean, I don't know that there's any reasonable person that would objectively think somebody going to a park would be outrageous. Your Honor, I really think that, I know the plaintiffs allege a lot within their complaint, maybe not as much as they should to be this cause of action, but the statement by the plaintiff's attorney that's alleged in paragraph 35 of the Second Amended Complaint and plaintiff's response to the motion, really what it's boiled down to the essence. What they really complain about is that the Laundries did not disclose Gabby's whereabouts. That seems to be the information that they really, that's really at the heart of their complaint. But what's interesting about their complaint is that they don't actually allege that the Laundries ever knew Gabby's whereabouts.
Oh.
As Mr. Melt said, it's insufficient for them to plead opinions, theories, legal...
What the hell is going on with this thing? Oh, they're like, what? I really want to hear the argument.
Gabby's whereabouts. As Mr. Melt said, it's insufficient for them to plead opinions, theories, legal conclusions, or argument. The court does not have to accept those as true for purposes of deciding the motion to dismiss. The only allegation of any substance that the Laundries knew anything is at paragraph 20 of the Second Amended Complaint. And there it says, it is believed and therefore averred that on or about August 28th, 2021, Brian Laundrie advised his parents, Christopher and Roberta Laundrie, that he had murdered Gabrielle Petito. They do not ever allege that Brian told his parents Gabby's location or any other details. And other than that one allegation, they don't allege any other conversations with Brian. They don't allege any conversations with Mr. Bertolino or some other source where they may have learned that information. They don't allege how, if the Laundries had that information, how they would have come to know it. For that reason, Your Honor, with respect to that issue, there are no allegations in the complaint other than conclusions or theories that the Laundries knew Gabby's whereabouts. And so if the plaintiffs don't even allege that the Laundries knew that fact, their cause of action can't be based on a failure to disclose it. Now, plaintiffs may try to argue that the Laundries' knowledge can be inferred from their other allegations. Your Honor, I would submit that that's not a reasonable inference. Again, first of all, they don't allege any other conversations with Brian Laundrie other than that one conversation. Second, as we know now, and as alleged in the complaint, Ms. Petito was found in a remote part of a national park in Wyoming. It's not a reasonable inference to assume that the Laundries would have known that location, or that they could have even found out where that was. Your Honor, intent is also a critical factor here, and one in which the plaintiffs offer no concrete allegations other than conclusions. I'll discuss intent again when addressing the plausibility of the allegations against the Laundries, but juxtaposing the intent required in order to commit this tort with the words of Mr. Bertolino's statement and the other allegations of the complaint, there simply is an outrageous conduct. The standard is, with regard to intent, that it's not enough that the defendant act with an intent which is even tortious or criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. And again, Your Honor, this is the Eastern Airlines case that I cited earlier. Rather, liability is established only where the alleged conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Now, Your Honor, I did touch on our argument with regard to the paragraphs earlier, but I'll go through it in a little bit more detail here. So the first paragraph of Mr. Bertolino's statement acknowledges the difficulty of the situation for both families, which is important. It acknowledges what the plaintiffs were going through and the struggle that the Laundries were also balancing. Certainly a situation that neither family expected to be in and one that was full of challenges for everyone involved. Now, you couple that with the third paragraph, which basically says, I'm sorry, I know you would like us to say more, but we cannot on the advice of our attorney. We are going to stay in the background. The statement conveys, we understand how hard this is for you, but our son is in trouble, and we have to rely on the advice of our attorney in this extremely difficult circumstance. Far from being outrageous, that is exactly what most people in that situation would be thinking and doing. Those two paragraphs are critical because they run contrary to the plaintiff's conclusory allegations that the Laundries acted with malice and ill will. To the extent the Laundries withheld information with some sinister intent, which I'm not saying they did, that is facially disproved by Mr. Bertolino's statement that the Laundries will not provide additional comment based on the advice of counsel. Now, the plaintiffs want to focus on the middle paragraph, which is probably why they omitted the other two paragraphs from the complaint. Now, the first sentence of the middle paragraph says that a search was organized in Wyoming. A factually accurate statement. I don't think anybody is disputing that. The second sentence, which says, we hope the search is successful and Ms. Petito is reunited with her family. Now, the plaintiffs claim that that sentence caused them distress because it made it seem as though Ms. Petito could still be alive. Now, on its face, the statement does not indicate that Ms. Petito was or was not alive. It is an ambiguous general expression of hope. And we've cited a number of sources in our brief where the term...
I think you can kind of hear her talking a little bit, the mother. I heard her say like, no, or something like that.
Reunited is used to describe when a deceased person's remains are returned to family members. That's a term used by the National Institutes of Health, the Reuniting Families Project, the United States Army, and a number of news organizations. Now, the plaintiffs dismiss this fact, but again, the plaintiff's subjective interpretation of the statement is not what controls. It's the objective interpretation. And those sources that I cited, government agencies and other news organizations, would use that word to describe when a deceased person's remains are returned to their family.
So you're saying from an objective standpoint, a reasonable prudent person, if they are told, we hope that Ms. Petito is reunited with her family, that the reasonable prudent person would believe that to objectively mean that her remains would be reunited?
Really, what
in all instances?
I'm not saying in all instances, in all contexts. Really, what I'm saying is that the statement is ambiguous, and so somebody reading that statement would not necessarily immediately jump to the conclusion she must be alive.
Okay.
And, Your Honor, with respect to the plaintiff's assertion that they interpreted Mr. Bertolino's statement to give false hope that Ms. Petito was alive, it's contradicted by the allegations of the Second Amendment complaint. So Mr. Bertolino made his statement on September 14th, 2021. And then 2 days later, the attorney for the Petito family, Richard Safford from New York, issued a statement to the Laundries, and it's found at paragraph 35 of the Second Amendment complaint. And I won't read the whole statement, but specifically within that statement, Mr. Safford says, we believe you know the location of where Brian left Gabby. And then later the statement says, how can you keep her location hidden? Please, if you have any decency left, please tell us where Gabby is located. Now, the attorney asked 3 times in that statement about Ms. Petito's location, but not once did he ask for clarification about whether or not Ms. Petito was alive. Clearly, at the time, the plaintiffs and their attorney did not believe that Mr. Bertolino's statement meant that Ms. Petito was still alive. I think it's also important.
I was about to say, like, are you effing kidding me? Oh, let's hear that part again real quick. Oh, shit.
Now, the attorney asked 3 times in that statement about Ms. Petito's location, but not once did he ask for clarification about whether or not Ms. Petito was alive. Clearly, at the time, the plaintiffs and their attorney did not believe that Mr. Bertolino's statement meant that Ms. Petito was still alive. I think it's also important to note that this statement by the plaintiff's attorney focuses on Ms. Petito's location as the information that the plaintiff sought. But as mentioned previously, there are no actual allegations, as opposed to opinions or conclusions, that the Laundries knew anything about Ms. Petito's location that they could disclose. Again, paragraph 20 only alleges that Brian informed his parents that he had murdered Ms. Petito, not the location. Again, paragraph 20 only alleges that Brian informed his parents that he had murdered Ms. Petito, not the location. And in that same statement,
That's kind of crazy. I'm really curious to see that letter. So the judge is supposed to make a ruling, I think, this Wednesday, from what I saw. The burn after reading letter that everybody keeps talking about. And I think the ruling is going to be whether it can be given to the parents or not. I think I saw something earlier. I think they talk about it in this hearing. I think maybe towards the end. I'm not sure.
Statement, Your Honor, by the plaintiff's attorney. He acknowledges the complicated situation faced by the Laundries. He says, "We understand you are going through a difficult time, and your instinct to protect your son is strong." Again, Your Honor, conveying that they understood why the plaintiffs maybe couldn't say more. They recognized the situation, the difficult situation that everybody faced. So again, that statement suggests that they were not insulted by their statement. They were not caused distress necessarily by the statement. They understood why the statement said what it did and why it didn't say other certain things. Your Honor, if we compared the plaintiff's attorney's statement with Mr. Bertolino's statement, I don't think that we would say that the plaintiff's attorney's statement was tortious. The plaintiff's attorney expresses understanding for the Laundries' unenviable position, just like Mr. Bertolino did. And then, questions whether the Laundries had any decency left and things like that.
What was decided today?
And arguably, Your Honor, the statement was a violation of the rules of professional conduct because it was an attorney directly contacting a party who he knows to be represented by another attorney, as opposed to going through that person's attorney. But regardless, Your Honor, the point is, we could parse every public statement that an attorney makes and raise a cause of action for intentional infliction of emotional distress, if that's what we're going to do in this case. This statement is not outrageous by Mr. Safford, and neither is Mr. Bertolino's statement. They're just public statements by attorneys during a very, very difficult situation for both families. Now, ultimately, the court has to decide whether Mr. Bertolino's statements were atrocious and utterly intolerable in a civilized community. And I would argue, Your Honor, if in a statement by an attorney that's expressing sympathy, hope, condolence, trying to explain the difficult situation of his clients is utterly intolerable in a civilized community, then I believe we've lost our way as a society. Now, I don't that the plaintiffs allege another statement by Mr. Bertolino, Your Honor, in which he says the news about Gabby is heartbreaking. The Laundrie family prays for Gabby and her family. Your Honor, I don't think there's any context in which that statement could ever be outrageous.
Are they saying too that Bertolino knew that she was deceased? I have a timeline. This is old stuff. I had a better timeline than this.
Outrageous. And regardless of whether the statement was outrageous, the complaint does not allege that Mr. Bertolino made that statement on behalf of the Laundries, as he did the September 14th statement, so it shouldn't be considered against them in any way. Now, Mr. Mel's touched on 2 cases that were probably the foundation of Judge Carroll's order. The first, Williams versus City of Mineola, and the site is that is 575 Southern 2nd, 683, and that's a 5th DCA case from 1991. Again, it's 575 Southern 2nd, 683. Your Honor, in that case, a 14-year-old died of an apparent drug overdose, but there was also an investigation as to whether or not foul play may have been involved. And the Orlando Sentinel published an article describing a party at one of the police officers' homes where they viewed the video and pictures of the autopsy of this young boy, where the audience were joking and laughing, mocking the pictures and whatnot. And now, the plaintiffs cite this case for the proposition that a grieving family is particularly vulnerable. And I would agree with that. That's what the case and the restatement, they do allow for that. But I believe the holding of Williams is a little more specific than that. Specifically, Williams said that a grieving family is especially sensitized to any disrespect or indignity directed at the decedent's body or representation of it. The potential for severe emotional distress is enormously increased in that situation. Your Honor, in this case, Mr. Bertolino's statement did not direct any insulting or disrespectful comments against Ms. Petito, so it is distinguishable from Mineola, City of Mineola in that regard. Your Honor, I would also comment F of Section 46 of the Restatement of Torts, which is the section regarding vulnerable family members. It states, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity.
Mo said in the chat that they're alleging that the Laundries knew and told him, and he released that statement. Okay. However, that would be so hard to prove.
Conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge, where it would not be so if he did not know. And now, this is an important part, Your Honor. It must be emphasized again, however, that major outrage is essential to the tort, and the mere fact that the actor knows that the other will regard the conduct as insulting or will have his feelings hurt is not enough. Now, the City of Mineola case, while it supports the notion that grieving families are vulnerable, it does not say that any statement by an attorney for a suspect in a criminal case is per se outrageous just because the attorney for the accused said it. There must be major outrage. It is also important to note that the behavior in this case, the Mineola case, was by the police officers investigating the death. Now, those police officers held a unique position as to the victim's family, as the victim's family would be relying upon them to fulfill their investigative duties in a professional way. Your Honor, the other case, the Liberty Mutual Insurance Company versus Stedman case, which was cited in Judge Carroll's order. It was the primary case he relied upon for his determination that context was important. In that case, Your Honor, the insurance company delayed paying for a double lung transplant for one of its insureds. A judge of compensation claims ordered the insurance company to pay for it. Despite that order, the insurance company ignored it and continued to delay with the intention that the plaintiff would die, and so they wouldn't have to pay for the lung transplant. Now, again, Judge Carroll cited this case for the proposition that context is important. First of all, Your Honor, one important distinction is the insurance company had a duty to pay for this surgery. Not only a contractual duty by the terms of their insurance policy, but they were also ordered by a judge to pay for it. And they ignored that duty in delaying paying for the surgery. Now, Your Honor, I do disagree with Judge Carroll in this regard. The basis for his statement, the basis for his holding was that Mr. Bertolino's statement was, by all accounts, benign and not outrageous. But if the defendants knew something or there was other context for the statement, then the statement could be outrageous. Your Honor, I would argue that if that were the case, that would impose a duty on the defendants to, if they spoke at all, to disclose something more than what they did.
Bertolino's this guy here, the bald guy.
And that's not a duty that they had. For example, if a reporter asked Mr. Riley and I a question, and we withheld some information in response to the question, we're not legally obligated to provide a complete and total answer with all the information that we know about that subject. That's certainly not a duty the law would impose on us. And in fact, Your Honor, in that circumstance, we would probably run afoul of the attorney-client privilege if we disclosed everything we know about it.
Or could Judge Carroll's order rather mean that with the facts ultimately coming to light through discovery and otherwise, that this issue may be one that is better suited, this question may be one that's better suited for summary judgment or trial?
I think you're right, Your Honor. I mean, I do think that that's what he was getting at was, I'm going to give the plaintiffs an opportunity to see if they can develop some additional facts, and then I'll reconsider this issue at summary judgment.
I mean, but we're still in motion to dismiss, so we're still kind of at the same spot that he was at.
Yes, Your Honor, we are still very much at that same spot. Okay. Although, again, as I said, Your Honor, my feeling is that even if the plaintiffs had some other information that they didn't disclose in that statement, and that's uncovered in discovery, that doesn't mean that they had a duty to disclose it. That they aren't required to disclose everything they know every time they speak. That even in this context, Your Honor, Mr. Bertolino's statement was very clear that they were not going to say more based upon the advice of counsel. That's important context for it. That conveys that you may not like what we said here. It may not be enough. It may not be exactly what you would want us to say, but we have a right to rely on the advice of our attorney and not say more. That I think is an important distinction, Your Honor. Your Honor, another issue related with the Stedman case, I know that the plaintiff cited on the issue of unequal positions, which again is another subparagraph of Section 46 of the restatement. But Your Honor, my position is that that's really a red herring. So what the unequal position section of the restatement said, it's subsection E of 46. The extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with the other, which gives him actual or apparent authority over the other or power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable, even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. The extreme and outrageous nature of the conduct may arise not so much from what is done as from abuse by the defendant of some relation or position which gives the defendant actual or apparent power to damage the plaintiff's interests. The result is something very like extortion. Successful actions have been prosecuted in this context based on outrageously high pressure tactics of collection agencies, other creditors, and insurance adjusters seeking to force an unfair settlement. And Your Honor, that's cited from Dependable Life Insurance Company versus Harris. That's 510 Southern 2nd, 985, specifically page 988, and that's 50 CA case from 1987. So, Your Honor, somebody involved in a criminal investigation making a public comment is not really what's intended by this subsection. The conduct must be something like extortion, where the person abuses their authority to extract something from the other person, and that's really not what we have here. Your Honor, I mentioned intent earlier, and the plaintiffs have alleged that the Laundries maliciously and willfully inflicted emotional distress. Now, in both of these cases that I just discussed, the intent is fairly clear. In Williams, police officers who were supposed to be investigating the victim's case openly mocked and joked about his death during a party. By all objective measures, very unprofessional, and done with the intent to mock the deceased, to make fun of him. And, Your Honor, just like Judge Carroll mentioned, duty is important in this context. And you could say that police officers have a duty, or at least an expectation, to be professional with victims and their families. Now, in the Stedman case, the insurance company clearly acted with the intent to disregard the judicial order, and with the hope that the plaintiff would die. The insurance company clearly acted with ill intent. Now, nothing about Mr. Bertolino's state comes close to that level of callousness. Nor did he have a duty to say more than he did. And other than general recitations of intent, the complaint has no specific factual allegation demonstrating that the Laundries or Mr. Bertolino harbored an intent to act outrageously or to do harm, which they're required to have. Rather, Your Honor, again, if you look at that first paragraph of this statement and the last paragraph of this statement, the first paragraph being that we're really sorry about this, but it's difficult for both families. We know you're going through something difficult, but we are too. And then the last paragraph where he says, I'm sorry, we can't say more based on my advice as an attorney. Now, the plaintiffs acknowledge that their cause of action on these facts is novel. And it is novel because Mr. Bertolino's statement is not outrageous. Everyone involved in this tragic saga had rights that protected them. And those rights may have worked to the detriment of others. But the exercise of those rights is not objectively outrageous. We can all imagine where the exercise of rights may be subjectively outrageous to the person who is disadvantaged by the exercise. But objectively, the law must protect the exercise of rights. Now, this leads me to my next argument, Your Honor, which is that Mr. Bertolino's statement was legally protected. There's two ways in which it was protected. The first, the privilege to do what is legally permissible, and second, the litigation privilege. So from the first recognition of the tort of intentional infliction of emotional distress, the Florida Supreme Court has emphasized that the conduct, although it would otherwise be extreme and outrageous, may be privileged under the circumstances. The actor is never liable, for example, where he has done no more than insist upon his legal rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. And, Your Honor, that's the Metropolitan Life Insurance Company case, which I cited earlier. It's 467, Southern 2nd, 277, Florida Supreme Court, 1985. And this principle has been upheld many times since, and we cite to some of those cases in our brief. Now, as an initial matter, our first motion to dismiss discussed a number of rights that protected the Laundries from having to say anything. And as Mr. Bertolino put it in his statement, they could remain in the background. That was their legal right. And Judge Carroll summed up that finding that the Laundries had no duty to do anything, even if the plaintiffs wanted them to do more. As I discussed, I disagree with Judge Carroll with regard as to whether or not that duty should be extended to whether they needed to say more in the statement, in Mr. Bertolino's statement. I would argue that the law doesn't impose a duty on them to say more than what they did. Ooh. Now, as it relates to Mr. Bertolino's statement more specifically, there is an additional way in which he was exercising his professional obligation in a permissible way. ABA Model Rule of Professional Conduct 3.6 permits an attorney to make a statement to protect his client from adverse publicity. Specifically, that rule says, notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect the client from the substantial, undue, prejudicial effect of recent publicity.
Thank you, Elizabeth, for the memberships. Appreciate that. She gifted 5 memberships. Appreciate that. So, make sure you guys check out the front page. I have members videos on there. We're overdue for a members video or stream too. Mandy, thank you for the 6-month membership. Amazing. It says so outrageous.
Not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. And again, that's ABA Model Rule of Professional Conduct 3.6, subsection C. Now, plaintiffs argue in their response that there are not enough facts within the second amended complaint to infer that Mr. Bertolino's statement was made under these circumstances covered by the rule. Your Honor, I would disagree. So, first of all, the plaintiffs allege that Brian Laundrie murdered Gabby Petito. That's at paragraph 16. They reference the search in Wyoming, paragraph 28. They allege that the Laundries and Mr. Bertolino were assisting Brian to flee the country. Again, we vehemently oppose that, but they allege it. They specifically set forth at least 3 public statements by attorneys that were published to the media for both families. It's paragraph 31, 35, and 38. They allege Mr. Bertolino's September 14th statement was intended to be disseminated nationwide and was broadcast in news reports in Florida and nationwide. Again, paragraph 31. They also allege that Mr. Bertolino released, I'm quoting, numerous other statements regarding Christopher Laundrie, Roberta Laundrie, and Brian Laundrie to the national press, paragraph 33. And they allege that Mr. Bertolino gave a televised interview in October of that year, paragraph 27. There are enough allegations to support that there was media attention on the case. Now, the rule itself does not require a certain level of publicity that the attorney is responding to. It just says recent publicity. It could be a response to one article about the case, but certainly the plaintiffs have alleged enough in here, and enough in their second amended complaint to support that there was publicity on the case that Mr. Bertolino could be responding to. Regardless of whether the facts of the second amended complaint fit neatly into the model rule, the standard is whether Mr. Bertolino and the Laundries were insisting on their legal rights in a permissible way. Even if every element of Model Rule 3.6c is not satisfied by the allegations of the complaint, the mere existence of the rule demonstrates that Mr. Bertolino had a good faith basis and legal right to make the statement. Now, plaintiffs argue in their response that if Mr. Bertolino was issuing a statement to protect his clients, he would have given what the plaintiffs wanted, which was Gabby's location. First, the rule does not specify what kind of statement an attorney must make. Second, such an argument would impose a duty on the defendants too, if they spoke at all, to disclose everything, which again, we don't believe the law imposes that duty. And then third, Your Honor, the statement Mr. Bertolino gave, while not satisfying to everyone, was the best he could do under the circumstances. It acknowledged the plaintiff's grief, while also informing them that the Laundries could not say more based upon the advice of counsel. Now, Your Honor, I'll turn to the litigation privilege.
With the ABA model rule, what would provide that as being legally permissible?
Well, Your Honor,
he's not a member of the. I mean, he's a member of the New York Bar.
Correct? Exactly, Your Honor. Yes.
So, and he was making allegedly those statements in Florida. So, are those model rules are intended to be adopted by bar associations? So I mean, I don't know that we have one in Florida bar that.
Your Honor, you're right. I don't know that we do. Although I would say I don't believe Mr. Bertolino made the statement in Florida. I believe he may have made it in New York or someplace else. Obviously,
he's not governed by the Florida bar.
Exactly, Your Honor. He is
so,
not.
I mean, I guess that's the ABA model rule. Those are just what they say. Model rules. We have model rules and laws nationwide. That doesn't mean that they're actually laws we have to follow.
No, you're right, Your Honor. And it's not so much that it's a law that he would be required to follow, but what it is a recognition that an attorney can make a statement like this, a public statement like this, and not run afoul of rules of professional conduct. It is a permissible rule, not so much a rule that seeks to.
But it's not a permissible rule in the state of Florida.
I agree with you. Right. Yes, it's not a permissible rule in the state of Florida. Okay. Yes, I would agree with that point.
I just wanted to make sure that there wasn't something similar in New York, or that you were going on.
I don't know about New York, Your Honor. I do know that in Florida, I don't believe that rule is part of our rules of professional conduct.
Selena, thank you for the 16 months. Wow, amazing, unbelievable. Love you, Mel, man. Thank you. Love you too. 16 months. Amazing. Why is this guy speaking 1,000 miles per hour? It's sped up because this is like a 4-hour thing. We're just getting to the 2-hour mark. Well, it's almost 4 hours. It's 3 hours and 40 minutes.
I'll bring it up, Your Honor. Excuse me, I'm just going to grab a sip of water while we're taking a short break here.
It's at 1.5, actually.
So, Your Honor, turning to the litigation privilege. Now, the litigation privilege is based on a recognition of the necessity that certain persons, namely attorneys in this context, because of their special position or status, should be as free as possible from fear that actions in that position might have an adverse effect upon their own personal interests, which is really what we have here. To accomplish this, it is necessary for them to be protected, not only from civil liability, but also from danger of even an unsuccessful action. Now, Your Honor, while that's important to my clients, is that if a principal's liability rests solely on the doctrine of respondeat superior, a principal cannot be held liable if the agent is exonerated. So if Mr. Bertolino can invoke the litigation privilege, then my clients cannot be legally responsible for whatever conduct he did that caused the invocation of that privilege. Now, Florida has recognized both absolute immunity and qualified immunity in the litigation privilege context. Now, typically, the absolute immunity is afforded to statements made in the course of judicial proceedings or trials. But it also includes proceedings before a competent court or magistrate in the due course of law or the administration of justice, which is to result in any determination or action by such court or officer. This privilege extends to the protection of the judge, parties, counsel, and witnesses, and arises immediately upon the doing of any act required or permitted by law in the due course of the judicial proceedings. And then here's the important part: or as necessarily preliminary thereto. And that, Your Honor, that's Fridovich versus Fridovich. That's 598 Southern 2nd, 65, Florida Supreme Court, 1992. And that's citing another Supreme Court, Ainge, for that same proposition. Now, Your Honor, as we pointed out in our brief, the Florida Supreme Court has not addressed whether absolute or qualified immunity would extend to a lawyer's comments in a situation like this. As the plaintiff's cause of action is novel, so is our request to extend the litigation privilege in response to it. Now, the Florida Supreme Court has extended the absolute privilege in certain pre-litigation contexts, specifically the Ainge case that I referenced. It's Ainge versus State, 123 Southern 9. It's an old case, Southern 916, and that's from Florida, 1929. And in that case, Your Honor, the court found that the absolute privilege barred an action for defamation based on statements made in the office of a county judge to whom the defendant had gone to obtain a warrant. Your Honor, also Roberts.
There might be a chase, by the way, but I'm keeping an eye on it. They get canceled all the time, but CBS is en route, stolen vehicle, so I'm going to keep an eye. If the chase pops off, ooh, it's like pouring outside, there's some thunder. Perfect. If the chase pops off, what I think I'll do is I'll start a new stream. I'll dub this live stream part 1. We'll do the chase, and then we'll start a new part 2, and we'll continue the rest of this if you guys want to finish. Because I think we should start a new stream if a chase happens. But we'll wait and see, because this shit gets canceled all the time. All right.
Versus Industrial Insurance Company. That's 75 Southern 2nd, 198. That's Florida Supreme Court, 1954. Absolute privilege applied to defamatory statements made in a letter to the insurance commissioner
Kelly, overhead,
used to initiate license
CBS
revocation proceedings.
Give me the last the page number for the Ainge.
Sure. So
123
123 Southern 916.
Thank you. Perfect.
Now, the Florida Supreme Court has also recognized a qualified privilege rather than an absolute privilege in the context of statements made to police in a criminal investigation prior to the initiation of criminal proceedings, and that was the Fridovich case that I cited to you earlier. Also, in Delmonico versus Traynor, the site for that is 116 Southern 3rd, 1205, Florida Supreme Court, 2013. And in that case, Your Honor, the Supreme Court extended the qualified privilege to statements made by an attorney as they undertook an informal investigation and interviewing witnesses. And so now, Your Honor, we acknowledge that this case does not fit neatly into any of these examples, and we would be asking the court to extend the privilege to the context where an attorney makes a public statement in the face of a criminal investigation of one of his clients. But again, Your Honor, relying on Model Rule 3.6, there is a basis for doing so. If rules of professional conduct contemplate an attorney making a statement or even compelling such a statement to fulfill a duty to defend his client, then there is no reason that such a statement should not at least be protected by a qualified privilege. We can all think of countless examples where an attorney for a defendant makes a public declaration of innocence, or a prosecutor makes a public declaration of guilt before the case is decided. And now every one of those cases should not trigger a civil action for intentional infliction of emotional distress if the case turns out differently than those proclamations. Your Honor, the basis for whether an absolute or qualified privilege, the basis of such a privilege is for lawyers is to permit a free adversarial atmosphere to flourish, which atmosphere is so essential to our system of justice. That's Sussman versus Damien, 355 Southern 2nd, 809, Florida, 3rd DCA, 1977. In fulfilling their obligations to their clients and to the court, it is essential that lawyers, subject only to control by the trial court and the bar, should be free to act on their own best judgment in prosecuting or defending a lawsuit
Guys, see the flash?
without fear of later having to defend a civil action for something said or written during the litigation. A contrary rule might very well deter counsel from saying or writing anything controversial for fear of antagonizing someone involved in the case and thus courting a lawsuit, as a result which would seriously hamper the cause of justice. And again, Your Honor, that's a quote from the Sussman case. Your Honor, it is an important point that Mr. Bertolino is an officer of the court, and subject to the court's jurisdiction and also regulation by his bar association. And if he truly did step out of line, he is subject to control by those entities. His clients and him also should not face a civil action merely because of his comments about an ongoing public investigation. Now, plaintiff's response discusses the case of Ball versus D-Lights Enterprises, Inc. The site for that case is 65 Southern 3rd, 637. It's a fourth DCA case from 2011. And Your Honor, all these cases I'm citing should be in the binders, citing and everything.
1 through 95.
Yeah.
And I don't want to cut you off, but I've given both of you, like, at this point, 45 minutes for Mr. Metz.
Taking too long, going on and on and on and on and on, referencing 100 different cases. I mean, I get why they do that, but all right, move on. So the pursuit was in LAX airspace. That usually so the choppers can't follow into there, but now it's eastbound Century Boulevard. So I'm just keeping an eye. I see.
45 minutes for close to 45 minutes for you, and I just want to make sure that
Understood, Your Honor.
Yeah, come on.
it's a similar amount of time.
I will move more quickly.
Okay.
I will move more quickly. So, Your Honor, in the Ball case, in that case, a party to a lawsuit published some disparaging remarks on their own commercial website about their opponent's business practices. Now, I can understand in that context why the litigation privilege would not cover it, because it was essentially a party to litigation disparaging a business competitor in a commercial context, entirely commercial context, and it just happened that the two entities were also engaged in litigation. This context is different, Your Honor. The statement is made by an attorney, and there is a rule of professional conduct that permits that statement. That type of statement is much more closely aligned with the litigation privilege than is the statement by a private entity on their website in a commercial business context. Turning from
At what stage are these cases that you're citing getting resolved? Are they getting resolved in a motion to dismiss stature? Or
some of them, yes, Your Honor. Although, I mean, I would submit, Your Honor.
I will look through them. And
yes, the litigation privilege probably is something that requires more factual development in certain contexts. I mean, now there may be cases where it's very obvious from the four corners of the complaint that there was a case that was initiated. I'm sure, the court could take judicial notice of certain things, if a case had been filed, if the case related, and things.
CBS almost overhead. All right. I'm going to set up the stream in the meantime. So again, if it happens, I'll start a new stream. I'll title this one Part 1, the stream here. And then we'll watch the chase, and then we'll come back. Part 1. And yeah.
It's like that. So that's obviously not the context we have here.
Right.
I do agree with you on that.
All right.
I do agree with you on that. Your Honor, Mr. Meltz covered causation. I'll just touch on it briefly here. So the Florida Standard Jury Instruction 410.6, which is the intentional infliction of emotional distress in jury instruction, says that extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. Now, the jury instruction does allow for concurring causes, but again, even a concurring cause must contribute substantially to producing the distress. Now, I don't think the plaintiffs dispute that there were concurrent causes, that they were already suffering their distress prior to Mr. Bertolino's statement, even after Mr. Bertolino's statement, that was not necessarily due to anything that Mr. Bertolino said. But, Your Honor, really what is critical here is the word producing, or substantially producing. Because as Mr. Metz pointed out, paragraph 35 of the complaint, within the statement by the plaintiff's attorney, Richard Saffold, he said, we haven't been able to sleep or eat and our lives are falling apart. Again, not caused by Mr. Bertolino's statement, just caused by the circumstances of the disappearance of their daughter. And also the way that the plaintiffs have alleged causation in this case is interesting. They say that the defendants could prevent such additional mental suffering and anguish of Joseph Petito and Nicole Schmidt by disclosing what they knew about the well-being and the location of the remains of Gabrielle Petito. It's paragraph 39. Failing to prevent mental suffering that is already occurring is not the same as producing it. The distress has already been produced. It's ongoing. And really what the plaintiffs are arguing is that the Laundries failed to stop it. Again, I think it's also important to point out that they allege the Laundries caused their emotional distress by not disclosing what they knew about the well-being and location of the remains of Gabby. And as Judge Carroll found, disclosure is not a duty they had. And it was also, the Gabby's location is not a fact that the Second Amendment complaint alleges the Laundries knew specifically. But what we are dealing with specifically here, Your Honor, is whether Mr. Bertolino's statement produced their distress. But they don't allege that the statement produced distress. They alleged that what was not in the statement caused them to suffer continued distress, which again is not the same as producing. Your Honor, Mr. Meltz also touched on this, so I won't spend too much time on it. For conduct to be actionable as an intentional infliction of emotional distress, the conduct must be directed at the plaintiff and in his or her presence. And that's Dunkel versus Hedman, cases 2016, Westlaw 487-0502. That's a Middle District of Florida federal case from 2016. We cite a number of other cases, Your Honor. I'm not going to do that now. They're in the brief for that same proposition. Now, in their response, Your Honor, the plaintiff, I think
it's already over.
In arguing against the application of the litigation privilege, which is at page 24, paragraph 55 of their response, they acknowledge this fact. They say, furthermore, the statements made by Mr. Bertolino were not made to anyone involved in any potential court proceeding. So the plaintiffs are correct. Mr. Bertolino's statements were not directed at the plaintiffs or anybody in any potential court proceeding. And as a result, they don't have a cause of action for intentional infliction of emotional distress. Now, Your Honor, my final argument, my plausibility argument, as I mentioned earlier, it's not...
They've been going for a while. Damn. Yeah, the judge already had said, like, both of you have gone for more than 40 minutes. And so I thought this guy was going to wrap it up. He's still fucking going. The chase, I think it's over, possibly. Pupscan said, no, the circle of death means that footbill or car stopped. I guess the helicopter's just going in circles. So I said a lot of these chases aren't really happening.
Not sufficient for the plaintiffs to plead opinions, theories, legal conclusions, or argument, and the court does not have to accept those as true. Now, the two cases that set the minimum standards for federal pleading, which Florida courts have expressed acceptance for, are Bell Atlantic versus Twombly and Ashcroft versus iCkEdMeL. Now, Your Honor, I would submit that this complaint is full of opinions, theories, legal conclusions, and argument. As mentioned earlier, there was only one allegation of a conversation between Brian and his parents in the whole entire complaint. And even that allegation begins with the phrase, it is believed. There are no allegations that the Laundries learned any other information than that one allegation. Now, I want to focus on the allegations regarding the state of mind. And now, specifically, they allege that Mr. Bertolino's statement was outrageous and that all of the defendants, all three of the defendants, acted willfully and with malice in issuing it. Now, plausibility means that once the complaint has been whittled down to its non-conclusory allegations, the court undertakes the second step of determining whether the complaint states a plausible claim for relief. The plausibility standard asks for more than a sheer possibility the defendant has acted unlawfully. Where a complaint pleads facts that are merely consistent with the defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. Now again, the plaintiffs have alleged that each defendant individually acted willfully and maliciously toward the plaintiffs. Now, it doesn't allege a conspiracy or some other agreement amongst the defendants. It doesn't allege that any of the defendants forced another one of them to do something. The complaint doesn't even allege that Mr. Bertolino and the Laundries ever spoke about the statement before it was issued. It alleges all three independently had that heightened mental state to inflict severe emotional distress. Now, the plaintiffs have to advance that theory because this is an intentional tort. This isn't a negligence action where the Laundries are liable for Mr. Bertolino's negligence simply by employing him. Likewise, Mr. Bertolino is the one who made the statement. So he can't be liable if he didn't have the intent to harm. But that dictomy creates an implausible scenario. If Mr. Bertolino, as plaintiffs alleged, harbored such malice toward the plaintiffs to intentionally inflict emotional distress, to deliberately commit an act that goes beyond all bounds of decency, he would have been acting for himself, not as an agent, as an attorney for the Laundries. If Mr. Bertolino allegedly committed an intentional tort for his own purposes and not on behalf of his clients, then his clients cannot be liable for the acts of their agent, and the Laundries should be dismissed. And we cite the Diaz versus Associated Loan Company. It's 99 Southern 2nd, 279, Florida, 1957, which says the liability of the master for intentional acts which constitute legal wrongs can only arise when that which is done is within the real or apparent scope of the master's business. It does not arise where the servant has stepped aside from his employment to commit a tort which the master neither directed in fact nor could have supposed from the nature of his employment to have authorized or expected the servant to do. If Mr. Bertolino harbored the mental state necessary to commit something so egregious, he could not at the same time fulfill his role as an attorney to the Laundries. It's hard to imagine a scenario where an attorney could commit an intentional tort and still be acting in his professional duty to his client. Making a statement that is utterly intolerable in a civilized society wouldn't be serving any client's interest. And if Mr. Bertolino, as the Laundrie's attorney, advised or even permitted his clients to issue a statement based on his own maliciousness, as the plaintiffs have alleged, then the Laundries could not have had the mental state necessary to commit the tort. They would have simply been allowing their attorney to act as their advocate, something that is not outrageous or to be regarded as atrocious and utterly intolerable. Now, if there is an obvious alternative explanation for the Laundrie's activities, the court can choose the more plausible conclusion. Where the conduct is more likely explained by lawful behavior, the complaint does not plausibly allege a claim for relief. The most obvious alternative explanation is that this was a very upsetting time for everyone, and Mr. Bertolino was simply trying to express that without doing any harm to his clients. As his statement said, on the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. Now, Your Honor, in conclusion, the plaintiff's pain and frustration with how the investigation into Gabby's disappearance occurred is understandable. Absolutely. We all have sympathy for them. But as judges and lawyers, we know that almost every case, criminal or civil, involves some pain and frustration for the parties involved. Now, most of the time, not to the level of losing a child, but there is some discomfort. As humans, we have yet to craft a perfect system where everyone is protected, the victim, the accused, their families, but that would be impossible because everyone has rights. And often those rights butt up against each other. For that reason, we have legal guardrails to keep everyone involved in an investigation from being sued every time. While the plaintiffs deserve our sympathy, they just don't have a case against the Laundries. Thank you, Your Honor.
Thank you. We've been going for about 2 hours. Would anybody be objectionable to like a 5-minute break?
I would love a short break.
Okay, let's do that. Mr. Riley, you don't mind since it's your time to go next?
I was going to ask anyway.
Excellent. All right. Let's see a little back. Let's 3:35. Let's do 10 minutes.
Okay.
Go take a little break.
All right.
You finally finished. Did I miss anything? Hell, Mel, how you feeling today? Oh, hello. I'm pretty good. I was, of course, a little hungover, but I had my this person that does IVs. She came by, and she, I think this afternoon she gave me an IV with vitamins and stuff like that. So I'm pretty good. I just gotta get probably a good night's rest, and yeah, I'm pretty good considering. All right, so 10-minute break. Let's see, skip forward then. I saw I think they had like a presser earlier too, or something, or some sort of conference, or I don't know where that's at. It's probably somewhere. At least we get to skip 10 minutes. Oh, yeah, DeSantis I guess it's official. He's running against Trump.
May it please the court. I think if Judge Carroll were here today, the first words out of his mouth would be, didn't I already decide these issues?
Oh!
Most all of the issues that have been raised here today have already been decided by Judge Carroll.
Oh, coming in. Oh, damn, lightning. Coming in hard. Savage. Does the IV thing help at all? I don't know. I guess it must. I don't know. From what I read online, the effects or the benefits can be immediate. 45 minutes to 4 hours after treatment, you can expect results. I've heard some people say the day after. I feel a lot better than I felt earlier. Pressure was after the hearing. Okay. Yeah, I went to the spa yesterday. I didn't see what you said. Cat C, apologize for what? I don't even see it. Don't worry. Oh, thank you, Winnie. Yeah, pink is one of my colors, I'm realizing. Yeah, we do need to talk.
Carroll in a very well-reasoned decision. The plaintiffs, or the defendants in this case, are simply looking at another bite at the apple to try to argue the same issues and hoping that you, as being relatively new to the case, will overrule what Judge Carroll previously ruled. There's been no new evidence that they've submitted, no new arguments that they've made that would make any difference. And for them to suggest that Judge Carroll didn't consider some of the elements of a cause of action of intentional infliction of emotional distress when he rendered his opinion is frankly insulting to Judge Carroll. The only change that occurred in this case between the first amended complaint and the second amended complaint is that Attorney Bertolino was named as a defendant. There were some jurisdictional allegations that were included, and there was a second article that was included. But beyond that, the bulk of the complaint, the majority of the complaint, the structure of the complaint has been ruled on in a motion to dismiss before Judge Carroll, and he found that it was sufficient to move forward. This case is not based upon silence. We're not arguing that the Laundrie's refusal to provide information regarding Gabby.
I had to let my new clerk in.
Okay.
So we should be okay. She's listening in good spots.
All right.
And then also this.
We're not arguing that the fact that they kept quiet about whether Gabby was living or wasn't and where her body was located is the subject of this cause of action. It's not. This is about the statement that was issued by Mr. Bertolino on September 14 of 2021, issued with the knowledge that Gabby Petito was deceased, issued with the knowledge, and we did suggest in the complaint of paragraph 28 that they knew where Gabby Petito's body was located. With that knowledge and knowing that Joe Petito and Nicole Schmidt were desperately searching for any information about their daughter, they issued a statement. And by the way, when that statement was issued, counsel Mr. Meltzer suggested that Mr. Bertolino was simply the attorney for the Laundries. He was more than that. He was also their spokesperson. He did all their speaking for them, whether it was related to a legal representation or not. He did all of the speaking for them. The statement that was issued on September 14, there's 3 paragraphs. The first paragraph says it's a difficult time for the families. It's a meaningless paragraph in terms of this litigation. The third paragraph says there will be no more statements issued, or that Laundries won't speak. Nothing to do with the crux of that statement, which is the subject of this cause of action. And that statement is, it is our, and I highlight our, understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our, and against, I emphasize our, hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. Counsel has suggested that this statement wasn't directed towards the Petito family specifically. But who else, if it wasn't directed to them, was it directed to? What was the purpose of the statement? What reason would there be to make that statement other than to express the hope to the Petito family that she would be located? Who else would they be expressing the hope to? Mr. Bertolino's suggestion that the statement was issued only on behalf of the Laundries is belied by his own language in that statement where he says our on multiple occasions. The defendants want you to take that statement and read it entirely out of context. They want you to believe that it was the sincere expression on the part of the Laundrie family and Mr. Bertolino that they hoped that she would be found. And if you looked at it in that context alone, arguably I would agree, it is harmless. It could sound like a heartfelt expression of a true desire that they hoped that Gabby Petito was located. But when taken in context and looking at all of the allegations in the complaint, it suggests that they knew when that statement was made that Gabby was deceased, that they knew where her body was located, and they knew the family was grieving. Mr. Meltz did a good job of cherry-picking portions of the complaint and taking them out of context, but let's put it in context.
Oh, shit.
On July, and these are all allegations that are in the complaint, July 2nd of 2021, Gabby and Brian embark on a Western U.S. journey in Gabby's van, paragraph 10 of the complaint. Gabby called her family almost daily, paragraph 13. There was no contact with Nicole Schmidt after August 27, 2021, no contact with Joseph Petito after August 21 of 2021. That's paragraphs 14 and 15 of the complaint. The paragraph 16 says, there's a belief that Brian murdered Gabby on August 27 of 2021, and the cause of death was blunt force injuries to the head and neck with manual strangulation. Paragraph 16. On August 28, Brian Laundrie contacted his parents. On August 29, his parents contacted Attorney Bertolino, and a retainer was sent to Attorney Bertolino on September 2 of 2021. That's paragraph 20. September 1, Brian returns home in Gabby's van without Gabby, paragraph 22. On September 6th of 2021 through September 7, 2021, the Laundries go on vacation with Brian while Gabby is missing. Paragraph 25. September 14, Mr. Bertolino issues a statement that I just read a moment ago. And again, as I said, paragraph 28 does indicate we believed that at the time it was issued that they knew the whereabouts of Gabby Petito's body. He also issued a statement on October 23rd of 2021 in which he said when Brian Laundrie left his home on, I believe it was the 13th of September, he was grieving. Definition of grieving is feeling sad because someone has died. On September 19 of 2021, Gabby's remains are located, and Mr. Bertolino issued another statement. The news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family. Her death wasn't news to the Laundries or Mr. Bertolino. They knew she passed away. The only news to them was that Gabby had finally been found. Putting Mr. Bertolino's statement in context, as Judge Carroll noted in his opinion on the prior motion to dismiss, if the Laundries and Bertolino knew that Gabby was dead, knew the location of her body, and knew her parents were frantically looking for her, the statement was particularly callous and cruel and is sufficiently outrageous to state claims for intentional infliction of emotional distress. That hasn't changed. None of that has changed by the filing of the second amended complaint. As the court knows, the motion to dismiss must be confined to the four corners of the complaint. Have to accept as true the plaintiff's allegations and draw every reasonable inference from those allegations in favor of the plaintiff. Defendants have taken liberty in their motions, as I have indicated in my brief, by bringing facts in that are not a part of the four corners within the four corners of the complaint, and I'll discuss that. As was noted, intentional infliction of emotional distress became recognized as a cause of action by the Florida Supreme Court in 1985 in the Metropolitan Life Insurance case. And the Supreme Court adopted Restatement of Tort Second, Section 46, which sets forth the requirements necessary to prove a intentional infliction of emotional distress. They are deliberate or reckless, not intentional, deliberate or reckless infliction of mental suffering. Both counsel, I believe, stated that it has to be an intent to commit emotional distress. That's not what it says. Deliberate or reckless infliction of mental suffering, outrageous conduct. The conduct caused severe emotional distress, and the distress was severe. On the element of deliberate or reckless infliction of mental suffering, liability for outrageous conduct, this is under the restatement, liability for outrageous conduct arises when the wrongdoer desires to inflict severe emotional distress, when that's the intentional part, or when the wrongdoer knows severe emotional distress is certain or substantially certain to result from his conduct, that's two, or the third way is when the wrongdoer acts recklessly in deliberate disregard of the high degree of probability that emotional distress will follow. The reasonable inference from the allegations raised in the complaint is that the Laundries knew, and Mr. Bertolino knew, that Gabby was deceased. They knew the location of her body. They relayed that information to Mr. Bertolino. All the defendants knew that Joe Petito and Nicole Schmidt were desperately searching for their daughter at the time that the September 14, 2021 statement was issued. And I would submit that the allegations are sufficient to support an inference that the defendants knew that the statement was going to inflict emotional distress on the parents, or they knew or were substantially certain that it would, or at the very least they acted recklessly in deliberate disregard of a high probability that that statement would cause emotional distress to the Petito family. On the issue of outrageous conduct, I agree with what counsel had said. It's required to be so outrageous in character and so extreme in degree as to go beyond all bounds of decency. It requires an objective evaluation of the claimed misconduct to determine whether it is atrocious and utterly intolerable in a civilized community. And the burden does fall on the court. It's a question of law initially, not a question of fact. And generally, it is found where the recitation of the facts to the average member of the community would arouse his resentment against the actor and lead him to exclaim outrageous. The restatement provides a non-exclusive list of examples of what outrageous conduct is. Comment C in particular says, the law is still in a state of development. The ultimate limits of the tort are not yet determined. The caveat is intended to leave fully open the possibility of further development of the law and recognition of other situations in which liability may be imposed. It's instructive to look at the cases that I've cited in my brief where there has been conduct that's found to be outrageous and where it's been found not to be outrageous. In the cases where it was found not to be outrageous, in Williams versus Worldwide Flight Services, a former employee claimed that managers and some of his other supervisors had called him racial names, created a false record of disciplinary actions against him in order to terminate him. They didn't allow him to work with other African Americans. They put him out in extreme heat and cold to load and unload planes, threatened him with job termination, accused of him stealing, and had him move dangerous and heavy equipment and cargo and work extra flights so that he couldn't take his breaks. The court found that while the conduct was reprehensible, objectionable, and offensive, it did not rise to the level of outrageous behavior. In LeGrand versus Emanuel, when 250 people were sitting in a church service, someone accused the minister of stealing money from the church to purchase a car. They called him Satan. They called him Macout, I think it's how it's pronounced, which is a name for the oppressive secret police from Haitian dictator Duvalier's regime. And they stated that his name means Satan. The court found that although they recognized branding a thief as being certainly unsettling, embarrassing, and or humiliating, it doesn't rise to the level of being outrageous. And finally, in Duval Hotel Management, bride and groom had reserved a room for their wedding reception. The day of the reception, the manager of the hotel told them the room wasn't available, and so they'd have to have their reception in the lobby of the hotel, where there was not enough room for the 190 people, and during the reception, there were other guests walking through the wedding party. Some of them attended the party, and some of them were walking through in swim trunks. The court said the bait and switch pulled by the hotel was not sufficiently outrageous to support a claim for intentional infliction of emotional distress. Now I'll move on to the cases where the court has found there was grounds for outrageous conduct and a claim for intentional infliction of emotional distress. In McAlpin versus Sokole, a woman went to a hospital because she had a throat condition. She was disrobed, she had on a robe, and she was sitting in the x-ray room when a doctor came in, unannounced, and in the presence of other staff, berated her for not paying another doctor's bill. He said he was going to call security and have her thrown out. She fled the room. She couldn't defend herself because of her throat condition. She fled the room, and the court found under those circumstances that there was reckless and outrageous conduct. In Nims versus Harrison, a teacher alleged that 2 of her students had written some sort of publication in which they used inappropriate, extremely offensive language about her. They threatened to kill her. They threatened to rape her and her children and her cousins. The court found on those grounds that's outrageous conduct. In Ford Motor Credit Company versus Sheehan, a collector on behalf of Ford Motor Company had been unable to find the debtor who was behind on payment for his car. The collector contacted the debtor's mother, claimed that she worked at a hospital, and that 2 of the debtor's children had been involved in a car accident, and she needed to get in touch with him, so the mother provided contact information for her son. In the interim, the son contacted the mother. The mother told the son about the phone call she'd received. He spent 7 hours contacting hospitals and police departments to find out where his children were, only to find out that it was false. The court found in that instance that that was outrageous conduct. In Dependable Life Insurance Company of Harris, the insurance company was required to make car payments to a bank if the debtor became totally disabled, which he did. He made his application. The payments were made initially, but then they stopped. The claims manager on 2 occasions contacted the debtor, called him a fraud, and attempted to frighten him from collecting under the policy. His car was ultimately repossessed. He went into bankruptcy, and he suffered emotional distress. The court found that was sufficient to make a claim for outrageous behavior and intentional infliction of emotional distress. In Liberty Mutual Insurance Company versus Stedman, the insurer, and this was mentioned by, I believe, Mr. Luca, the insured alleged that the insurance company delayed authorizing a double lung transplant, even though they'd been ordered to provide it, because they learned from the decedent's doctor that she didn't have long to live, and if they waited this out, in their mind, if they waited it out, she'd die, and they'd not have to pay the cost for the lung transplant. The court found, and I think it's instructive in this case, the appellate court found that viewed in isolation, the conduct the insured had alleged with respect to the lung transplant is not so outrageous that it qualifies as atrocious and utterly intolerable in a civilized community. That's the position the defendants are taking in this case. The statement itself may be benign, taken in isolation, but the court considered. However, paired with her specific allegation that the insurance company knew, based on testimony from the insured physicians, that she had a very limited life expectancy, and further considering that the insured was well aware that the clock was ticking, and that the additional emotional distress caused by the delay could well hasten her demise, the court found the conduct fell within the ambit of comment F of the restatement. Comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly, I have trouble with that word as well, Mr. Luca, peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge where it would not be so if he did not know. That is our allegation in this case. The statement's benign. Put it in context. Look at what they knew at the time the statement was made. That's what makes it outrageous. In Williams versus Mineola, another case that was cited to by Mr. Luca, There was a drug overdose. The police officers took pictures of the decedent, went to a party, and then circulated and made jokes about it. In determining whether and I will point out, by the way, in that case, the conduct was not directed at the party who was filing the lawsuit. This was something that was done at a party and was discovered later on. In determining whether the conduct of the officers was outrageous, the court stated, as for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida, show a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to family feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it is entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering physical trauma because of the loss of a loved one and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved. Finally, in the case of Thomas versus Hospital Board of Directors, the decedent died during hip surgery in a hospital, and the death resulted from the physician giving an overdose of a particular medication which caused cardiac arrest. The doctor and the staff inside the surgical suite decided that they were just going.
Yeah, the chases just haven't been what they used to be. They're just, I don't know. I mean, they're still happening, but like they're ending really quickly by the time the chopper gets to them. I mean, I remember, I don't know, somebody the other day, I said chases are dead, and he was like, I disagree. Somebody, one of those news people, I think. And I think he says they're happening more frequent or something. The chases aren't what they used to be. I mean, we used to have times where there was like 3 chases in a day or something. I remember one day we had 3 chases in one day. It was crazy. Back to back. I think it was like a semi truck was stolen. I forgot what else. They're just not what they used to be anymore. I don't know what happened. Yo, Buzzballs, I like that. That's pretty good. Buzzballs. Jenny says, has anyone tried Buzzballs? Yeah, they're pretty good. I've had the chocolate one. I've had the margarita ones. I think I like the margarita ones more. I had the chocolate and the margarita ones.
Going to simply say that she died
full of sugar. That thing's got to have like a ton of sugar in there.
Or as a result of the stress from the surgery. And that was, their report was issued, and an autopsy was not completed on the body for that reason. A week later, daughter of the decedent was burying her mother, and she, while doing so, received a phone call from the coroner saying she needed to immediately return the body back to the hospital so that a proper autopsy could be performed because he had learned of the real cause of death. The court found the decedent's daughter had sufficiently pled the elements of a cause of action for intentional emotional distress and said, as noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, the actor's conduct may become heartless, flagrant, and outrageous. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. Like the last 2 cases, the Thomas case and the Williams case, we're dealing with a person. We're dealing with someone who was deceased. And we're dealing with parents who were incredibly vulnerable because of the fact that their daughter was missing and they didn't know where she was. And I think this falls within those types of cases where, as was noted, I think in the Williams case, special deference is paid by courts to family feelings where the rights of dead bodies are concerned. Comment F, which I already spoke to comment F. At the time the statements were made, according to the allegations of the complaint, which the court must accept as true and which the court must draw all reasonable inferences from, the defendants were aware of the vulnerability of Joseph Petito and of Nicole Schmidt to emotional distress because of the uncertainty of where Gabby was or if she was even alive at the time the statements were made by Mr. Bertolino. The conduct of the defendants became heartless, flagrant, and outrageous when the statements were made in the face of such knowledge, where otherwise the statements would not have been so outrageous or heartless or flagrant. At this stage, it's not the plaintiff's burden to prove the allegations of the complaint. The question is whether the allegations as pled are sufficient to make out a cause of action, and I would submit that they are. Comment E to the restatement also says, in support of the outrageousness requirement, an unequal position of the parties in a relationship where one asserts power to affect the interest of the other may supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Again, the defendants knew that Gabby was deceased. They knew where her body was, according to the allegations of the complaint. They knew that the Petito family was desperate and upset. And had they just kept quiet, we wouldn't be here. If they had kept that knowledge to themselves, we wouldn't be here. We wouldn't be standing before you having this argument. But they didn't just keep quiet. Instead, with that unequal position in which they stood vis-a-vis the Petito family, they made that statement of hope. And they knew, or they should have known, that that would affect Joe Petito and Nicole Schmidt and cause emotional distress. Defendants suggest somehow that looking at the full statement from September 14 of 2021 will make a difference in the court's determination of whether or not there's outrageous conduct. The first paragraph and the third paragraph simply say it's a difficult time for both parties and the Laundries are going to keep quiet.
I forgot to, let me get the super chat from earlier. Mari, thank you for becoming a member. I hope you're doing well. Cherry, thanks for the super chat. Says, off topic, but wanted to comment on the dog from yesterday's chase. It had its face slammed in that gate. I think it affected its initial reaction. Oh, interesting. KSGO M, thank you for the for the membership, 12 months. Good day, Mel. 12 months of laughs, late nights, and early rises. You and the iCkED fam chat have helped me get through this last year. Love you all. Thank you. That was nice.
That does not in any way soften the blow of the content of the second paragraph. I'm frankly surprised that both defendants have suggested that the term reunited is subject to interpretation. They suggest it could mean the person is not alive, and they cited two various articles in which remains were reunited with a family. But the statement doesn't say, we hope the remains of Gabby Petito are reunited with her family. It says, we hope the search for Miss Petito, not her remains or her body, is successful and that Miss Petito, not her remains and body, are reunited with her family. Frankly, I think the defendant should be embarrassed for raising such a ludicrous interpretation of their own words. And by the way, if those words are subject to various interpretations, that's left to the jury to decide what it means based on credibility determinations. We believe the allegations clearly satisfy the requirement of setting forth a factual basis for outrageous conduct. And I cited the court to the Williams case where it said if differing inferences can reasonably be derived from the facts alleged, the question of outrageousness is for a jury. I'll move on to the suggestion that Mr. Bertolino's statements are protected. I would agree, as they said, that a statement made by the defendants, although extreme and outrageous, may be privileged under certain circumstances, but there are no such circumstances in this instance. As the court pointed out, the ABA model rule of professional conduct is not binding on any, don't even know if it applies. It's a model rule. But suppose it is something that we should consider. It says an attorney may, doesn't say shall, doesn't say must, an attorney may make a statement to protect the client from adverse publicity, and in making that argument, the defendants go outside the four corners of the complaint. They suggest that Brian Laundrie and Roberta Laundrie and Christopher Laundrie received a great deal of publicity, that statements were being made about them, and that Attorney Bertolino had a right and duty to protect his clients from prejudicial effect of that publicity. Well, that's not what the ABA standard says. It doesn't say he has a right and duty. But none of this is referenced. This publicity is nowhere within the four corners of the complaint. And more importantly, looking at that statement, if that's what Mr. Bertolino's intention was at the time he issued that statement, how does a statement expressing hope that Gabby Petito is reunited with her family, how does that protect his client? If he wanted to protect his client, he should have disclosed where Gabby was. Even if he had a right under those circumstances to make that statement on behalf of his clients, it didn't give him carte blanche to cause emotional distress, nor does it give him immunity from liability for issuing the statements. It simply says he can make them. It doesn't say under all circumstances he has that right. As far as the litigation privilege, it does exist in Florida to a degree. It allows litigants and counsel to zealously advocate positions in court. Defendants suggest, again, going outside the four corners of the complaint, that statements were made. At the time the statements were made, there was intense law enforcement and media investigation. I'm not sure how you find that in the complaint, but they say the only reasonable inference to be drawn is that the Laundries faced a criminal investigation and media inquiries. Well, I don't know that there is any law that says reasonable inferences must be drawn in favor of the defendant. It says in favor of the plaintiff. They state that based upon the fact that there was a potential criminal investigation, Mr. Laundrie has a litigation privilege, Mr. Bertolino has a litigation privilege to make that statement. It's not reasonable to suggest or to infer that the Laundries were the subject of an investigation, although it would be with regard to Brian Laundrie, unless Christopher Laundrie and Roberta Laundrie committed a crime that we're unaware of. The ARCO case that was cited and referenced by Attorney Luca, when it talks about the absolute privilege, says, the absolute privilege, the Florida Supreme Court has explained, is part of a trade-off. The absolute privilege was created to encourage zealous representation and the free and full discovery of facts between the parties and the court. This absolute immunity resulted from the balancing of two competing interests, the right of the individual to enjoy a reputation unimpaired by defamatory attacks versus the right of the public interest to a free and full disclosure of facts in the conduct of judicial proceedings. The question here is, what was the judicial proceeding? What proceeding was going on? What proceeding was anticipated at the time that he made these statements? We don't know. There isn't one. And the statement has to be made in context of those proceedings, and that's the Ball versus D. Lights Enterprises, which I cited in my response. This, if they're suggesting the statement was made in reference to this particular litigation, it wasn't even contemplated at that point in time. Absolute immunity does not apply or include a publication of a defamatory matter. This is the Ball to Lights case. Does not apply to or include publication of defamatory matter before the commencement, or after the termination of the judicial proceeding, unless such publication is an act incidental to the proper initiation thereof or given legal effect thereto. Nor does it apply to include any publication of defamatory matter to any person other than those to whom, or in any place other than which, such publication is required or authorized by law to be made for the proper conduct of judicial proceedings. Again, what judicial proceedings were undergoing at that point in time. The statements must be made, according to the ARCO Plumbing case, which I cited in my motion, the statements must be made to the court, to parties, to law enforcement, or witnesses. That's the ARCO Plumbing case. In this instance, the statement was made to the press, directed to Joseph Petito, Nicole Schmidt, and the entire Petito family. That's admitted by Mr. Bertolino in his motion to dismiss. In Buckley versus Fitzsimmons, which I also cited in my response, the court held statements at a press conference do not have any functional tie to a judicial proceeding. They also suggest they might have a qualified privilege, but that's only available when statements are made to police during a criminal investigation, and that was set forth in the Delmonico case. Mr. Bertolino cites to the Orange Lace Country Club case, but the court stated that statements necessarily preliminary to judicial proceedings include pre-suit communications required by statute or by contract as a condition to suit. There is no contractual or statutory obligation which would apply here. Defendants have suggested that there's an issue with causation, and they suggest that perhaps there's no discussion of causation in the complaint, but paragraph 40 of the complaint clearly says the emotional distress was caused by the statements made by Mr. Bertolino. They also suggest that the statements must be the sole cause of the emotional distress, and they cited the court to the standard jury instruction in civil cases 410.6, but they only told you about subsection A, not subsection B, which says, defines a concurring cause, and this is in the instruction for intentional infliction of emotional distress. In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. It may be a cause even though it operates in combination with the act of another, if the extreme and outrageous conduct contributes substantially to producing such emotional distress. That's what we have in this case. In this instance, we have a family undergoing distress, wanting to know where their daughter was. She hasn't contacted them in a long time. And along comes this statement made by Mr. Bertolino, and the statement we would submit is a concurring cause of the emotional distress. Restatement, comment J to the restatement says, severe distress must be proved, but in many cases the extreme and outrageous character of the defendant's conduct is in itself important evidence that the distress existed. The allegations of the complaint show the conduct itself the nature of the conduct itself fits within comment J because it's so extreme and outrageous. Knowing someone has passed away, knowing a family is grieving to express false hope that she may still be alive is outrageous. Attorney Luca also discussed the issue of agency. It's an interesting argument in which the Laundries seek to distance themselves from Mr. Bertolino by suggesting that because the complaint alleges malice, he was acting alone and not on behalf of the Laundries. But as Judge Carroll noted in his opinion, an attorney's acts are the acts of the principal, the client. And that's the Stinson versus Pravat case, where the court said the principal is liable if the wrongful act is done while the agent is acting within the scope of his apparent authority, even though the act was not authorized by or was forbidden by the employer, or was not necessary or appropriate to serve the interest of the employer, unless the act was done to accomplish his own purposes as distinct from the employer's business. That sounds more like an affirmative defense to be raised or an argument to be made at a later time that he wasn't acting on behalf, that Mr. Bertolino was not acting on behalf of the Laundries when he made that statement. But within the four corners of the complaint, there's nothing to support that argument. In fact, the statements themselves issued by Mr. Bertolino say we and our. In sum, I would submit to the court, I do want to address two other issues that were raised. I apologize. I believe I've addressed them. In sum, I would submit that, just as Judge Carroll found, the allegations of the Second Amendment complaint are sufficient to set forth a cause of action for intentional infliction of emotional distress, and both motions to dismiss filed by the defendants should be denied. Thank you.
Ms. Riley, I do have a question for you. If you look at, for paragraph 40
Of the complaint?
of the complaint, paragraph 40, subsection A and B, you began your argument indicating that this is not a silence case. This is about statements made.
And Judge, I'll agree to strike those two paragraphs. They shouldn't be there. I agree.
Okay.
We're not.
They're talking about Ron DeSantis because he was doing he was supposed to have this Twitter Spaces thing, an announcement, and apparently it didn't go well, or I don't know what happened. Ron's presidential campaign start as a disaster. He is owned by George Soros. George Soros was there? No. What? I'm more interested in seeing what the hell happened.
This cause of action is not based upon their silence.
So then you will strike A and B, C, D.
Yes. I'm not going to take out the factual allegations earlier where that was said, because in my view, that shows, of course,
That shows the context. But
Right.
but I do recognize Mr. Metz's point in that because we don't have specific, to each of these counts, we don't have a specific title for the count. It would, the complaint is intended on making sure that we understand which statements we're actually talking about. And I also recognize in your paragraph 43, where it says,
Wake
with
it up.
regard to Mr. Bertolino, he released numerous other statements regarding Christopher Laundrie, Roberta Laundrie, and Brian Laundrie to the national press and to the Florida and into Florida in particular. While Mr. Metz kind of breezed by that as far as a jurisdictional statement, are these statements that you are also indicating could have caused?
No, that was purely for jurisdictional.
Okay, so therefore the statements that we are talking about here are specifically the statement of hope that was done at that we've talked about ad nauseum here.
Yes.
And then the prayer statement.
Yes.
And then that's it.
Yes.
Okay. All right. Thank you.
Thank you.
I am
Too fast?
assuming you all know that I'm going to reserve on this particular issue before ruling. So that is what I'm going to do on the motions to dismiss. And I hope to have orders out for you all shortly with regard to those. We do have two other issues that we need to address. Oh,
Judge, I maybe had a rebuttal I could do in 1 minute. Could I just
1 minute.
Yes.
Yes, you can give me a rebuttal.
Timing you.
Go for it.
1
Like
minute.
the trial attorney that comes up for cross-examination says I have one more question.
Judge, I gave a closing once in 22 minutes for a 4.5-week trial, so I'm going to do this.
Okay.
Paragraph 40 doesn't talk about causation. So Mr. Riley said it did. It doesn't, and causation is missing throughout. Mr. Riley talked about recklessness. Count 3
Fire back.
and count 6 does not raise recklessness. It raises willfulness and maliciousness. There are 4 elements to intentional infliction of emotional distress. At best, Judge Carroll partially commented on one of them. You take those 4 elements as a checklist, and you read through this complaint, and you read through all of the counts, you're not going to check all 4 off. It doesn't set forth a cause of action for intentional infliction of emotional distress. It doesn't have all the elements. And that's within the 4 corners. And for this type of claim in particular, your role and what the courts have said are your responsibilities in the scope of what you can rule on clearly puts you as the gatekeeper for this. And there's not sufficient evidence for it to move beyond this point. Thank you.
Okay.
It's a minute and 20 seconds.
Twitter glitches. At the end of this, we'll take a look at Twitter and see what happened. Twitter glitches plagued DeSantis 2024 campaign announcement. Oh, shit. Twitter Spaces crashes repeatedly during DeSantis 2024 announcement. Oh, no. Loud. What happened, man? What happened? You guys didn't have... They should have had special servers just for that, Twitter Spaces. Nearly 700,000 users, maybe because there's so many people, logged in to hear the announcement roughly 20 minutes after it was launched. The event was then abruptly shut down without explanation. The servers are straining somewhat. I mean, that is a lot of people. Musk was heard saying at one point, Twitter users pummeled Musk over the botched rollout, and Democrats were quick to capitalize. Oh no, even Joe, you know that's not Joe typing that shit. Whoever his representative or managing his stuff. Joe over here trying to pop when he said this link works. You could try this shit because homeboy's thing is not working. Oh no. Ooh. This is the most embarrassing thing that's ever happened to a presidential candidate. I highly doubt that. And it's not close. Just hold a rally, David Mark says. Another commenter tweeted. And the MAGA War Room tweeted an image of Twitter Spaces and the word failing to launch. All right, we'll take a look and see what happened after.
I had a comment. Mr. Luca, did you have anything else you wanted to add?
I'm sure everybody would appreciate it if I didn't speak again, but I would just ask the court to consider. I know Mr. Metz mentioned that counts 3 and 6 had the willfulness, maliciousness language as opposed to deliberate and reckless. It's the same for all the counts against all of the defendants. So to the extent that you're considering that argument, that applies. It wasn't just for the counts that applied to his client.
Okay, gotcha. All right, so I'm going to be reserving on that ruling. The rebuttal has not made me change my mind on that.
JB tweeted it?
And
Take a
we've
look.
got our next issue. What would y'all like to handle next, gentlemen?
How you spell his name? JB Bueno?
Do the easy one.
JB.
Which is the third request for production of documents where I asked for any account statements which showed transactions.
Ooh, here's the laundry's burn after. Ooh, let's check it out. Oh, sorry. Let me download the images. I can make a video out of this too. Letter 1. Ooh. Oh shit, that boy got the exclusives. Letter 2. Bueno. Ooh, bueno. Okay. Thank you for that information. Who said that in the chat? All right, let's get to it. Let's cut to the chase. Oops. No. Okay. So the burn after reading letter has finally been released. JB posted this on Twitter. Brian Christopher Laundrie, burn after reading. I think, here we go. Let's try to read this. I just want you to remember I will always love you. And I know you will always love me. You are my boy. Nothing can make me stop loving you. Nothing will or could ever divide no matter, I don't know what's it, divide us, no matter what we do or where we go. What we say, we will always love each other. If you're in jail, I will bake a cake with a file in it. If you need to dispose of a body, I will show up with a shovel and garbage bags. If you fly to the moon, I'll be watching the skies for your re-entry. That's kind of weird. Some weirdo shit. If you say you hate my guts, I'll get new guts. The fuck? Remember that love is a verb, not a noun. It's not a thing. It's not words. It's actions. Watch people's actions to know if, well, that's really true, actually. To know if they love you, not their words. That's actually so true. That really rings. A little bit weird, though, but that does ring. Damn, so over here talking about bodies and bags, and I'll be there with you. I'll dispose of the bodies for you and shit. I don't know, what the gut thing was kind of weird. If you say you hate my guts, I'll get new guts. What? Therefore, I am certain that neither death, nor life, nor angels, nor the ruling spirits, nor things present, nor things to come, nor power from above, nor power from below. Nothing in the entire created world can separate our love. This is some, like, I don't know. Yeah, you guys have something going on? Neither hostile powers nor messages of heaven nor monarchs of earth. Nothing, I don't know what that says. Nothing have the power to separate us. Romans 8:38, extended version. Nothing can separate us. Not hatred, not hunger, not homelessness, not threats, not even sin. Not the thinkable or unthinkable can get between us. Not time, not miles and miles and miles. What the heck? Damn, bro. Ride or die mom. I mean, I don't know. If your kid killed somebody, would you be... I don't know. I don't know about no bringing body bags and a shovel and shit. I can go down with you. Maybe I'll be there in court. Maybe, I'll send you some letters. Maybe I'll visit you in prison. But, what the heck? That Meg, that's what isn't that kind of what it sounds like? Meg said, I hate moms who sound like they want to F their sons. Wow. Wow. Mamma mia. All right, thank you guys. So I made a video for that now. I'm going to post it after the stream. Oh. Mamma mia. That's some weird shit, ain't it? Sound like lovers or some shit, like girlfriend, boyfriend, husband, wife type of shit. My mother would not write me no shit. I'd be in trouble. I'd be saying all kinds of shit. I'm here for you forever. The stars will never separate us. Ride or die. From above and below, all over the world. Never separated. You can do anything. I'll be there for you, no matter what. And what was that letter written? That just sound like she knew. What was that letter?
And Mr. Lupa has indicated that all those transactions were for payment to Mr. Bertolino, and that he was satisfied to have the court take a look at it and determine if he's correct. And I'm fine with that as well. If the court looks at it and says there's no withdrawals or transfers in excess of $10,000 that went to anyone, that didn't go to anyone other than Mr. Bertolino, then that satisfies my inquiry in that area.
Okay, and I looked at that earlier today.
Hey, Judge, these motions don't involve me. Would you mind if I stepped out briefly?
Sure, absolutely.
Thank you.
Where the hell did that video save? Oh. Okay.
I've got copies of the records if you wanted to.
Okay,
take a look at
because you
them.
gave me, I know that I have the.
Well, I got them here if it's easier
She
for me to
saved-
hand them to you.
Okay.
The letter was not dated. Okay, yeah, right.
Part of
Thank
the
you,
process
Mohawk.
is different.
Your Honor, I don't know if we included this one because I don't know if I had it at the time. This
Okay.
sort of explains, this is just a check, sort of explains like one of the entries.
Oh, okay.
So, Your Honor, so if we look at these records, first of all, when we're talking about transfers, I know Mr. Riley said that he wasn't interested in payments to Mr. Bertolino. There is a payment that's from Mr. Bertolino too. So let me, if I could just explain the records to you, this might go a little more quickly.
Okay.
So if you look on, so one page of the bank statement is for a checking account and one page is for a savings account. Mm-hmm. So if you look on September 1st, there's a fairly large deposit. Mm-hmm. And that deposit corresponds from that check from the law firm. That's a law firm that's associated with Mr. Bertolino. Mm-hmm. So that's what that check is. Then that that amount of money is transferred from the savings account to the checking account, and then about a week later, there's a check that's written to Mr. Bertolino. So
For far less.
for far less, yes. But then the remainder of the money just stays in the checking account. And so, Your Honor, that the payment that came in, the deposit, was for like a business transaction, totally unrelated to anything in this case. And you'll see that the check that was deposited is actually dated August 13th. So it would be outside of Mr. Riley's third request for production, outside that date range. It also would have predated anything that would have happened between Brian and Gabby.
So I'm not interested in that. I know what that is, and I'm not interested.
Okay, so then the only other transaction would be the payment, the check to Mr. Bertolino about a week after that.
Okay. If you just give me 1 second, because I want to specifically look at the production request, and then I can affirmatively tell Mr. Riley that you have given him everything he needs or not.
So I haven't given him these records because again, they don't meet with.
I know, but what if I'm going to look at his request, specifically look at his request, look at what you've given me, and then tell him he doesn't have to give them to you, or he does.
Okay.
Okay. And it's request number.
It's the third request for production. I believe it's the only request within that production.
That's a good thing to say there, Cheek. Cheek said a lot of us will go to the ends of the earth for our kids, but I'd be dipped in shit if I'm sitting in court pleading my case. Loving you would be turning you in, and we face facts together.
September 14th.
Burn after reading. Son, I love you. No matter what, I'll always be there. I'm a ride or die bitch.
Based on these records, your none of this would comply with your request.
Okay, I'm satisfied.
Thank you.
Thank you.
So then, as far as the motion to compel, based on my in-camera review, I'm going to be denying the motion to compel. And Mr. Luca, you could prepare the order for that?
Yes, thank you, Your Honor.
Wonderful. And Mr. Luca, just to make sure that it doesn't end up out in the world, I'm going to give you this back.
Okay, thank you, Your Honor.
I'm giving you back your entire tab 5 of that.
Thank you.
All right, and we have one additional motion we have to take care of.
Yes, Your Honor. The only remaining motion is the motion for protective order.
Chat acting up again?
And this relates to the letter that was authored by Roberta Laundrie, which we discussed, I believe, at our last case management conference.
Yes, sir.
So this is just the motion that now brings it before the court.
Okay. And if you would like to, it's your motion for protective order, so if you'd like to get us started.
Thank you, Your Honor. Your Honor, we filed an affidavit of Mrs. Laundrie explaining her authoring the letter and the purpose of the letter. Her affidavit explains that she wrote the letter to Brian and never intended for anyone else to see it. She wrote it prior to Brian and Gabby leaving for their trip, so it does not relate to any of the events that occurred thereafter. Her choice of words, in hindsight, are unfortunate, but that doesn't mean that the letter is relevant. Plaintiffs argue that Mrs. Laundrie's affidavit is a self-serving statement of a party, so the court should disregard it. Of course, the plaintiffs don't offer anything that contradicts Mrs. Laundrie's affidavit other than that argument. This was a private note between a mother and a son. They would have been the only people to know the circumstances regarding its creation. Mrs. Laundrie is the only person who can comment on it at this point. Now, the letter is undated, although she wrote the letter because she and Brian were experiencing a difficult period in their relationship, and he was about to leave home. He was about to go on this long trip with Gabby. And she was hoping to repair their relationship before he left. Now, there are several contextual clues within the letter demonstrating that it was written before Brian's trip. And, Your Honor, I did provide you with a copy of the letter, I believe. So first, Your Honor, the letter doesn't mention Gabby at all.
Judge, how can I respond to this if I don't see the letter?
It is.
Well, first of all, Your Honor, I would note that Mr. Riley has seen the letter.
I don't, that was well over a year ago, and I don't have.
He has a point.
Okay, so I understand.
With the contextual clues, it's hard to give context. I mean, with the last motion that we had, that's an easy thing for me to look at, and hopefully Mr. Riley to trust that I can read a bank statement and say, hey, there's none of these things that you're asking for in it. But you're asking me to make an interpretation, and that I think due process would permit him to be able to argue that.
Understood, Your Honor. Understood. So let me just bypass then referencing any of the content of the letter.
All right.
So going back, Your Honor, we have provided this affidavit from Mrs. Laundrie that explains the context in which she wrote the letter.
Come on, it's already 9 o'clock. Shit.
And the plaintiffs certainly don't offer any evidence or any contrary affidavits that Mrs. Laundrie's affidavit is incorrect, or any other information regarding why the letter was authored, when it was authored, any of those details. They simply call it a self-serving attempt to withhold a key piece of evidence. And this leads me to my next point, Your Honor. This letter is not a key piece of evidence. It was a private note between a mother and son. The plaintiffs never saw it. The letter has not caused them any emotional distress. And more specifically, the plaintiffs haven't demonstrated that the letter had any connection to Mr. Bertolino's statement, which is the foundation of
Just skip the rest?
Now, the plaintiffs cite to HEPCO Data, LLC versus HEPCO Medical, 301 7th 2nd 406. It's a Florida 2nd DCA case from 2020. And also to Dees versus Kidney Group and Kiker versus Lopez. Those sites, again, are in their motion. For the argument that irrelevancy is not a proper ground for protective relief under Rule 1.280 Section C. Now, Your Honor, I believe that misreads the point that those cases were making, which is that for a protective order, there has to be something in addition to relevance as an objection. There must also be a showing of annoyance, embarrassment, oppression, undue burden, or expense. In other words, relevance is not enough. For example, the Dees case that the plaintiff cite said, the protective order prevents any discovery concerning 2 prior clients and a new venture formed by the other 2 members of the company. The information appears relevant to Dees' claim or reasonably calculated to lead to the discovery of admissible evidence. Again, so the Dees court considered relevancy. It was just that you needed to go that extra step about showing embarrassment or oppression, undue burden, or expense. And, Your Honor, we've cited to a number of cases in our brief, which we provided to you, where courts precluded discovery on matters that were irrelevant or not reasonably calculated to lead to discovery of admissible evidence. Just to give one example, in Hoogland versus Dollar Land Corp., it's 330 2nd 509, 4th DCA 1976, the court held, the appellant Hoogland was entitled to a protective order as to most of the material sought until such time as it may appear that discovery of those documents is relevant or that may reasonably lead to relevant evidence. So while not the only factor, relevance is a significant part of the court's consideration. The plaintiffs still have to comply with Rule 1.280B, which only permits discovery regarding matters that are relevant or reasonably calculated to lead to the discovery of admissible evidence.
Why do you believe that this letter you've seen it, now I've seen it. Why do you believe that this would not be relevant?
Well, Your Honor, as Mrs. Laundrie's affidavit states, it was written.
Aside from statements made by your client, which arguably have a credibility factor that has to be addressed by a fact finder, what would be the reason that this would not be relevant?
Well, Your Honor, if I can't use the affidavit and I can't use the actual words of the letter, to describe why it wouldn't be relevant, I'm not frankly sure what to say, because those are the actual content of the letter and Mrs. Laundrie's affidavit are the reason why it's irrelevant, because she says she wrote it before Gabby and Brian went on their trip.
Okay.
My argument regarding the context of the letter was going to be that shows that it was written before they went on their trip.
Because this sounds like an argument that you make at trial when everybody has seen what you're trying to present, and then at that point in time we dire the witness, we make some credibility determinations, and then we decide whether or not it's relevant or not relevant. Rather than at protective order discovery stage where we're bringing in Mr. Riley here with his hands tied behind his back, not knowing how to argue it. I mean, essentially, when I took away the affidavit and the words of the letter away from you, I essentially put you in the exact same position that Mr. Riley is now in.
I understand, Your Honor. I mean, but certainly, he has the affidavit. He has the ability to develop additional evidence through the course of discovery, take Mrs. Laundrie's deposition, stuff like that, where perhaps he could develop.
Ask her about a letter that he doesn't know.
I'm not suggesting that. I'm just saying that the only facts that we have at this point are the facts that we have.
I understand. We're very early.
Right. And Your Honor, the reason why, this letter is particularly sensitive is even the plaintiffs acknowledge in paragraph 20 of their response
it's sensitive.
that it is understandable that the Laundries would argue that the letter is embarrassing and most prejudicial to Roberta Laundrie. And our concern in this case is.
But that's not to be fair, that is not an argument for discovery, not being required to turn over something in discovery. That is an argument for a motion in limine.
Well, no, Your Honor, it is an argument for discovery because under the standard for the protective order, if something is embarrassing, it can be protected. Okay, so in this situation, what we have is something that is embarrassing, and given the media attention on this case and how this letter could, would be put out into the public potentially, it's on fire.
Are there, and please correct me if I'm wrong on this or lead me in the right direction on it, but there is case law that suggests that the protective order does not necessarily prevent the other side from getting the discovery, but rather prevents the dissemination.
Well,
I mean, is there a middle ground here rather than, plaintiffs do whatever they want to with it and you saying it never gets to see the light of day? Is there a middle ground here where we can proceed and actually give them some meaningful attempt to utilize it and determine whether or not it would be a relevant exhibit at trial?
There certainly could be, Your Honor. We could, if we wanted to, we could work something out where we do enter into a protective order whereby Mr. Riley could see the letter and then.
Because that's not my understanding of what you're asking for in your protective order.
Right, that's right.
Your protective order is like I want it to be shredded and gone and forever and ever.
Right. I am asking for a Rule 1.280C protective order, meaning we don't have to disclose it, as opposed to a protective order where Mr. Riley and I agree to some terms as to the protection of it, like how it can be used, who can see it, things like that.
Okay.
Now, that's something we could certainly work on. Although, Your Honor, I think I would be remiss without saying that regardless of, if you totally disregard Mrs. Laundrie's affidavit, totally disregard.
I'm not saying that I am.
No, I understand.
I'm asking you the questions so that I can see the full crux of your argument.
Come on.
I understand.
Come on.
It's still, there is still a requirement that discovery is limited to those matters that are relevant to the litigation as framed by the parties' pleas. Okay? And so in this situation, the plaintiffs don't dispute that they've never seen the letter. They don't dispute that Mr. Bertolino's, other than maybe in his association with this case, has seen the letter, but that he saw the letter at the time he issued his statement, or that it had any influence on his statement, or anything like that.
They have alleged, however, that the defendants knew that Ms. Petito had passed and knew of the location in which her remains lay, and that factual allegation is one that they will have to prove in order to be successful at trial, because without knowledge, then so while this statement may not have been the one to have caused the intentional infliction of emotional distress, it is the ramp up to that. It's the elements that it potentially could allow the elements of that to be proven. Does that make sense?
No, it does make sense, Your Honor. I can understand that perhaps, but again, I can't reference the contents of the letter, so I'm just trying to, I'm struggling a little bit to make sure that those words don't come out of my mouth.
Judge, I don't know if this would be helpful, but so it sounds like what we're really talking about is whether a confidentiality order should be in place. And in all fairness, I think we've probably asked certain things from the plaintiffs in terms of written discovery where that may not be a bad idea. But of course, if you sort of start the discovery process without one, it's harder to get back in.
I agree.
So perhaps whatever ruling the court makes, we at least would have some grace period to consider putting a confidentiality order in place, because that might help alleviate everyone's concerns for other issues moving forward as well.
That is an idea to consider. I want to hear, Mr. Luke, I have interrupted you a lot.
Oh, no, that's fine, Your Honor.
You are helping me out, so I appreciate that. I appreciate the indulgence.
Yes, of course.
Even though if it's annoying, I'm sorry. Mr. Riley, would you like to?
Yes, Your Honor. As the court well knows, we're not suggesting that the letter caused emotional distress to my clients. We're suggesting the letter, if determined to have been written after Gabby passed away is proof that they were aware that Gabby passed away at the time that the statement was made on September 12th. That's the importance of the letter. As we all know, the letter references burying a body, bringing a shovel and burying a body, baking a cake and putting a shiv in it. Those are criminal acts, by the way, that Roberta Laundrie has said she would commit. But those words are in that letter.
I don't think shiv's in the letter, but.
Or then a saw or something, baking something in a cake. And by the way, her reference in her affidavit to these children's books that has tried to explain why she wrote that letter to her son is ludicrous, because there's nothing about burying a body or bringing a shovel or putting something in a cake if somebody goes to prison, although Mama Bear did say she would bake Little Bear a cake on his birthday. This whole argument is based upon the affidavit of Mrs. Laundrie. Mrs. Laundrie is a
When
party.
she said bake a cake with a file, I took that as for him to break out or some shit. Is that how you take it? Like for him, to what do they do with the filing, to make holes or some shit? Or I forget or they file down shit or bars. I don't know. I think she was trying to say that like if you're in jail, bake a cake with a file in it. I think to break out or like stab somebody. Do you want to give him a shank?
Mrs. Laundrie has bias and prejudice and a reason to say the things that she did in her affidavit. And if I were in her shoes and I had written that letter, I'd probably say the same things. But that subjects her to a credibility determination, and the court can't determine her credibility based upon that letter, and credibility is for the jury to determine. The cases that I cited regarding relevancy are all second. Two of them are second DCA cases. One is a fifth DCA. None of the cases that Mr. Lucas cited in support of his position with regard to relevancy are second DCA opinions. And also, it's their burden at this point to show good cause to protect them from annoyance, embarrassment, oppression, or undue burden or expense that justice requires. Well, I haven't heard from them what justice requires under this circumstance that would entitle them to a protective order. But the basis of their argument is relevancy. And again, Mrs. Laundrie has admitted she wrote the letter. The counsel's admitted that the letter is undated. It's up for a jury to determine, or up to a jury to determine when the letter was written. But I cited the court to the HEPCO case, which says relevancy is not a proper ground for protective relief under Rule 1.280C, and that's 301 Southern 3rd 406. It's a 2020 second DCA opinion. I cited the court to Dees versus Kidney Group, a 2009 second DCA case, which says it upheld the circuit court's finding that the information sought to be protected is not related to any pending claim, and the fact that it is not reasonably calculated to lead to the discovery of admissible evidence is not sufficient to issue a protective order. And I also cited the case of Kiker versus Lopez, a fifth DCA case from 1998, which held that holding that the argument that information is not relevant to the issues in the lawsuit does not satisfy the moving party's burden to show that producing the requested information would subject him to annoyance, embarrassment, oppression, or undue burden or expense. The simple fact that it might cause her embarrassment is in and of itself not sufficient to issue a protective order in this particular case. We're not talking about compromising pictures. We're not talking about financial information. We're talking about something penned in the handwriting of a party to this particular case. The cases, none of the cases that were cited by Mr. Luca support the suggestion that a protective order can be issued based upon the affidavit of a party, not one of them. That basically what they're asking you to do is to make a credibility determination at this point, which will preclude me from moving forward with a certain piece of evidence, a critical piece of evidence in this particular case, to show what information the Laundries had at the time that Mr. Bertolino made the statement. So I don't see any grounds upon which they're entitled to a protective order in this instance.
Say I agree with you, Mr. Riley. What argument would you have against a confidentiality?
Why? I have no reason to. I have no reason to agree to a confidentiality agreement. I mean, that hampers me. Why would I agree to a confidentiality? So then, if I'm asking her about it in a deposition, so now the deposition transcript is going to be confidential as well, or a portion of it. I mean, I don't see a reason why I need to be hamstrung. We're not talking about financial information, which would be the appropriate subject of a confidentiality agreement. We're not talking about trade secrets. We're not talking about something that, if is disclosed, is going to give some party an advantage, an outside party an advantage in moving forward, such as if trade secrets were disclosed. That's not what we're talking about. We're talking about a letter in the handwriting of a party.
Mr. Luke, do you have something to add to that?
Your Honor, I think at this point, we probably wouldn't be in favor of a confidentiality agreement on this issue either, just because Mr. Riley just put probably the two worst parts of the letter on the record in open court. So, I mean, and that's what we would be dealing with that throughout the litigation. I mean, he can.
Okay, so y'all don't want to, you just want me to rule then?
I think we just want you to rule.
Okay, very good.
Okay, anyway, so it's over.
That made that decision easy.
The judge, obviously, I guess, ruled out let's see. The judge ruled to be given at Gabby Petito's family, included a look at the envelope. It says burn after reading. Judge Brewer has denied the motion of protection for Roberta Laundrie's burn after reading letter. Okay, the family could be granted a letter written. Okay, so it was denied. All right.
Both attorneys, I appreciate both of you answering my questions. I really do. And at this time, I am going to be denying defendant's motion for the protective order. Are there any other objections with regard to this particular piece of discovery that are currently pending?
No, Your Honor. No, Your Honor.
Mr. Luca, is there any reason why I would not be able to give Mr. Riley the letter today? Or if you all have an extra copy, anything precluding me from doing that?
The only thing I would want to do would maybe put a bait stamp on it.
Absolutely, that sounds.
But other than that, I mean, I suppose you can just give him that copy, and I can bait stamp it, provide him with that like at a later
Do
time.
it for the love with me.
That sound good?
Yes.
Does that work for you,
horrible.
sir?
It does.
Okay, and would you write? Would you do the proposed order?
I will.
Okay, very
So
good.
there's a chase, right? I mean, there's no helicopters there yet, but it says Want is a major narco suspect. Ooh, interesting. That sounds good. Narco suspect. I like it. I want to make a thumbnail and whatever for this other shit. I guess I'll hang around for a few minutes to see what happens with this thing. I wanted to clip this I forgot where it was at. Where are you? Let's see.
Based on the, you could prepare.
Okay, thank you. And the purpose of
Mr. Riley.
it's like one of the entries.
Oh, okay.
You did okay, yeah,
Right.
right.
I have.
Okay,
Thank you. I looked at.
Or
where was that at? She knew. What was that? What was that letter?
And Mr. Lupa has indicated that all those.
Fuck it. Let's see. If it's and they lost the vehicle. Amazing. Amazing grace. Amazing. Major narco suspect gone. Oh, that's beautiful. Okay. If there's a chase tonight, I will come back. I just clipped a little burn after reading thing, so I'm gonna post that like within 10 minutes. If you already watched it, if you could do me a favor and just hit like on that video when I post it, I'd appreciate that. And yeah, I guess that's it, man. Thank you guys for hanging out with me tonight. I'll keep an eye on this. I guess I'll keep an eye on this. We'll see whenever. There's a couple things coming up that in June, I guess, right? The Cobra stuff should be interesting. I really need to start writing down some of the court date stuff coming up. There is a story I've been meaning to cover as well. Maybe tomorrow, I'm not sure. Maybe tomorrow I'll jump on and do that. Depends. A little short live stream. So, but yeah, thank you guys. Love you. Have a good night. Take care. Peace.